items which were kept in the shed. And also key is offered. And today also I have brought the key. They can take the.
My lord, let they file in respect of this memo. I would request the court to direct them to file an affidavit to that effect.
No, you verify. You verify.
No, they are just saying in this memo stating under intimation to the petition now it is vacant, and these
That
respondents
you verify that. I'll have it day after tomorrow. If it's removed, it's removed.
next week. My lord.
I'll have it on Tuesday. You verify.
Please.
File memo.
My
You file the
application
memo.
may also be directed to be put up. My application for modification of order I have filed. That was not listed now today.
No. Now, what is your main prayer? To hand over.
Main prayer is
To hand over physical possession.
Yes.
Now he says he has removed the scrap.
Yes.
You verify it. He says he's ready to give you the key. There ends the matter. You verify it.
In respect of that, earlier also, it has gone to ombudsman. Before the ombudsman, they filed one intimation, page number 49.
No, now you verify. He's filing the.
Please.
The counsel for the respondent bank submits that the scrap has been removed.
Memo is also filed.
Memo is filed. Same is taken on record. Petitioner to verify and take stand regarding the same. Relist the matter next week date.
Along with my application or file yesterday. Yes, that will come, my lord.
Let us see.
Yes.
9, Pradeep Patil.
My lord, this matter pertains to life convict premature release matter.
Huh.
For extension of parole, where the petitioner's
Request for
brother
time
was
till Monday,
released.
my lord.
Huh?
Request for time till Monday. I'll verify and my lord make my submissions.
You find out. Now, whatever procedure that is
All I am
prescribed,
seeking for extension, man, already granted by this honorable court.
extension of what?
On parole, after completion of 14 years, the name will be recommended to the life convicts premature release committee. The committee will, the state committee will send the same to the center. It will be pending.
But how can parole be given when this?
What
matter
happens,
is
my
still-
lord?
My lord,
Can I make my
in
submission?
the case of Rashidul Jafar,
Yes.
What happens here is, my lord, their names go to the advisory board. Eventually, my lord, it has to be decided whether they have to be released or not. Sometimes the advisory board takes a lot of time to decide it. The High Court now says, my lord, you can't take your own sweet time in deciding these matters. Therefore, we give them an extended parole of 90 days till the application is decided. Orders have been passed, my lord, by the coordinate bench of this court. That is what is there. I'll have to just verify, my lord, what the status is before the advisory board. Your lordship may have it on Monday, my lord. I'll make my submissions. Accordingly, extension can be given or
There
not.
is the order for.
my lord, at
Granting
page number 50, my lord.
Page?
Page number 50. And operative portion at page number 52, my lord.
But at least you should file an application.
No, I already filed. I have been extended for
extension.
90 days parole also. Now all I am seeking is order portion E. Extension. Already granted, my lord. And surrendered also. All I am asking for extension now.
Where is your application for extension of parole and before the authority?
My lord, we have submitted before the life convicts advisory committee. On that only we have got this order.
Decision to extension parole has been taken by,
Sorry, my lord.
decision to grant parole has been, which is the authority which has taken a decision?
Respondent number, respondent number 2, my lord.
So have you sought for extension there?
My lord, the thing is, first our name will be considered in the advisory committee.
Counsel, I'm asking you, parole has been granted by the second order of the second respondent.
Yes, my lord.
Have you sought for extension there?
My lord, we don't, as per my knowledge, we cannot go for extension. We have to go by the orders of the court only, my lord.
My lord, as parole has been granted by this court, my lord, the extension also will have to be granted by this court. Therefore, a separate writ petition is usually filed as a matter of practice.
So at least an application must be filed.
My lord,
You must at least file an application for extension.
My lord, to file an application, there is a difficulty. We cannot go and give the application there.
You file it here at least for extension.
My lord, I have been given a liberty in page number 53, my lord. At last, para number E.
Till when is the parole order in operation?
Already lapsed, my lord. He has surrendered also. 90 days has lapsed. The parole was granted in the month of November 22nd. And he has surrendered as well, my lord, after 90 days.
Then you take a call. I'll have it on Monday.
This matter can be called on Monday, my lord, so that my friend will seek instructions.
Now, if as per the notification at annexure A, you follow whatever procedure, then you expedite it. Relist the matter on Monday in the same stage.
Grateful. So grateful, man.
Number 10.
Appear for the petitioner counsel. There is an order by this court on 2/5/25.
Yes.
Really, sale deed
Yes.
has been released now.
Released. The writ petition becomes infructuous by virtue of the document being released.
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 File a memo. Counsel for the petitioner submits the government, the document
Kept pending.
which was
23/5/25.
kept pending before the respondent authority has been released
Released on 23/5/25.
on 23/5/25. In light of the memo filed and submission made, petition is dismissed as having become
Infructuous.
infructuous.
11. Anil Kumar.
For petitioner matters,
Yes.
I seek for a short accommodation.
On what ground?
Senior is not well.
No, that's okay. Now, what is it? Why don't you want to appear before the authority? Yes, state.
My lord, notice has been issued, my lord, to open a Rowdy sheet.
He says it has been stayed.
I am not aware of that order, my lord. I verified the order.
He has produced copy
Yes,
saying, so if there's, what is the guideline? What is the order? Government order, or is it in the police manual, or where is it provided?
I will call
What is the law? It's contained in what? This guideline for declaring a rowdy sheeter is contained in what document? What is the legal position under the police manual?
in the police manual.
Ah. So now they are saying it has been stayed. So what is your stand now? Find out and get instructions.
Yes,
Interim order earlier granted is extended till the next date. Relist the matter on
next week anyway.
date code.
11. 12. Serial number 12. Mahesh Kumar.
Petitioner.
Yes.
The petitioner is seeking parole.
Yes, who will take it? Find out. State. What ground is seeking parole?
That's for the construction of renovation of house.
Is that a ground enough to give parole?
Because
You find out, madam. You find out to get instructions. If it's a genuine case, you are satisfied, you make your submission, let us see. You find out from your authority what is the genuineness of it, on what ground it has been rejected.
My lord, it's in page number 13, my lord. Next year B, my lord. The reason has been stated, my lord. But the reason that he's stating to get parole is that, my lord, he wants to renovate the house, my lord. In this, my lord, they say that, my lord, the house has to be renovated, but, my lord, as there are old rivalry between the relatives of the petitioner, my lord, there may be chances of quarrel and fights between the two groups, my lord. For that reason, my lord, they have denied parole.
That you find out if there is a serious threat of enmity at the village, etc., then we'll see.
I will find out.
You find out and you satisfy yourself before you take a stand. Relist the matter on. Yes. Date. Yes.
Please. 16.
You can't give parole for the asking. It has to be for some genuine reason.
Yes, ma'am.
Yes. But you satisfy yourself. If there is some genuinity in the claim, we will consider. Yes.
13. Srinivasan MY.
Relist short date. Short date. MVC.
9.
9.
14.
For Eastern,
Respond in this
yes,
case,
for
my lord.
2 weeks time to deposit the amount, my lord.
Lord, the
Kindly.
File.
loan has been, it was declared as an NPA the year 2019 itself. Auction was conducted on 28/2/2025. Auction,
Slowly. Loan was declared.
pardon me, madam.
Loan was declared NPA.
Lord, loan was, NPA, it was declared in the year 2019 itself, Lord.
Yes.
Then the auction was conducted. Auction was conducted on 28/2/2025. Total outstanding, my lord, is about 24 lakhs 50,000. Auction reserve price was 60 lakhs, but the final price was 84 lakhs 26,000. Auction purchase has deposited, sorry,
Auction was conducted on
28/2/2025,
28 to.
2025, February.
Now sales certificate is given? No.
Not been issued, by virtue of, because of the interim order in this matter, the sales certificate has not been issued, but he has made the 25% deposit immediately within 1 week of the auction confirmation. And for remaining amount, he's kept the DD ready, but for this order, my lord, unable to go.
Now what does the Supreme Court say? That we cannot interfere at the stage of redemption. Redemption of mortgage
Please, my lord.
cannot be done once notice is issued.
Notice is been issued.
This is Pardiwala's judgment.
Please, my lord, I'm not carrying the copy of it.
That's the position, isn't it?
Please, my lord.
My lordship, within 2 weeks, we will deposit the
No.
amount, my lord. Kindly.
No, I'm sorry.
Due to some
I'm not going
financial
to-
crisis,
I'm
we
not
are
going to
not able to
intervene.
deposit.
No.
Kindly.
It's impermissible. Which paragraph of that judgment?
Lord, I am not carrying, I'm so sorry, my lord.
That is the position, isn't it?
Please, my lord.
Once a notice, auction notice is issued, the question of redemption doesn't arise.
That is the direction.
You have not complied with the interim order also.
Also, just twice,
My
in
lordship,
fact,
kindly.
on the last occasion.
At
it was
least 1
additionally-
week time
No,
may
no.
be granted.
No, I'm not going to
At
give.
least.
I'm not going to give you.
Kindly, my lord.
I'm sorry, I'm
Due
not
for
going to
some
give you.
financial crisis,
No,
only we
this
are
is an
not able
abuse.
to.
No, please don't misunderstand. This is not the way you to conduct proceedings in SARFAESI by coming to the court and getting interim orders. Court should not intervene.
If
You are aware
having
of
the
what the
amount, we are-
Supreme.
yeah,
No,
we
no,
would have pay before only.
no.
Kindly.
Auction has been conducted, sir. You can't. It's impermissible. After
so
auction,
many
you
years
can't.
of hardship, we are
No,
able
you
to
can't.
purchase
We don't have jurisdiction. That's what Supreme Court has said. I'm not saying that. Have you
We
gone
are
through the
ready to-
judgment?
we are
Have you
ready
gone
to-
through the judgment?
No.
And then, you know,
We are ready to repay the loan.
you
my lord.
cannot,
Due to
we
some-
cannot do that at this stage. That is the position in law. How do I overrule the judgment of the Supreme Court?
After years of hardship, we are able
No,
to
no.
purchase a property
The-
with their assistance.
I don't have discretion in this matter. You tell me how to overcome this Bafna Motors case. You tell me. Sir, this is a court of law, sir. I'm not a court of equity. I have no jurisdiction. Please understand. This has to stop. We cannot. Which paragraph? I'll have it at 2:30. You point out which
Please, my
paragraph.
lord, I will do it.
Now I'm only on the point
Please.
whether his right of redemption is still open
Please.
once auction notice is issued.
Yes.
Now this is a case where after auction notice is issued, auction process has also started.
Yes,
and he is a successful bidder
Yes.
and he has paid the 25%.
yes,
Now from that Bafna Motors case,
very well,
which paragraph you point out at 2:30, I'll dispose it of.
very well.
Pass over.
16, 15 urgency number 16, Purdy my HS.
Kindly pass over, my lord. Senior
No, this matter,
Yes,
my
what
lord,
do you- what do
we
you
called
say?
after a week's time.
No,
And
now,
also- Hello.
if it is so that there is excess, then you have to,
No, my lord, there was no demand.
Hmm.
Well, what they claim is under 44(2), is unjust enrichment. That does not arise in this matter.
No,
Because
they-
voluntarily they have paid the stamp
no,
duty.
that may be so, but you find out
Yes, ma'am.
if it is a mistake on their part.
Yes, ma'am.
If according to their, what value that
Yes,
they have
ma'am.
declared,
Yes, ma'am.
if there's a mistake, then you have to refund it.
My lord, whatever is declared in the document, my lord, as per the act, my lord, the definition,
No, correct, but you just, what they are saying,
they have paid by mistake.
that you find out.
That
If
I-
according to their valuation,
Yes, ma'am.
the amount paid is
3%
in
of the
excess,
value was to be paid.
Ah.
They have paid 5%, 2% in excess.
that you find out.
So that I'll find it, there is a provision if you can
If
refund.
there is a, no, if there's a mistake, then we'll order.
Yes, ma'am.
If there is a mistake
Genuine mistake, then
in the calculation of the stamp duty, then you have to make good.
difficulty is this, my lord.
No, by court order will pass.
Yes, ma'am. Yes, ma'am. Yes,
If
ma'am.
there is a mistake,
Yes, ma'am.
you give the calculation. In law, what is it that you had to pay? How much you have paid? What is it that you have declared? You make a one-page note. We will pass an order. Relist next week, date good.
Yes.
11,
Yes.
17, Girish R.
Application in this case, ma'am.
Yes.
Parole application, my lord.
You find out, madam.
Kindly.
I am not going to give parole for the asking, but if there is a genuine case, you get instructions and make submission. They are claiming,
Well, my lord, in this case,
Renovation
that has
of-
been rejected because his bail application is pending.
what is the legal position?
Bail itself is not granted, my lord.
No, correct. So what is the legal position in the
I'll produce that, my lord.
in the endorsement? You have made one Karnataka at page 15.
That notification, I'll place it on record, my lord.
Now, if bail application is pending, then you cannot decide.
Yes, my lord. That parole cannot be given, my lord, when bail applications are pending.
Then you place it on record. Let
I'll
us
place it on record.
relist the matter. When will you place it?
Next week, any date, my lord. I have it.
Relist the matter. Same stage on
16,
the AGA to clarify the reference to the notification dated 29/4/2022
Please, my lord.
at annexure A. You find out if the notification doesn't permit, then we cannot do anything. What has happened to your bail application?
Still is pending, sir.
Huh?
It's pending, application is pending.
Then how you can ask for parole? That you examine, you make submission. If in law, there's a possibility, I'll consider.
serial number 18,
My lord.
30,
My lord, in this case, I'm for the petitioner, my lord. I'm supposed to pay 5 lakhs, my lord. I
Okay,
have
for the
paid
respondent
1
bank,
lakh,
my
my lord. Another 10 days
Petition is
time will
become-
be granted, I'll deposit and
No,
and
no,
petition has
regularize
to
the
be-
loan account, my lord.
Yes,
Petition has to be dismissed, my lord, for non-maintainability. A appeal was filed before DRT, condition was imposed. They did not comply, DRT vacated the interim order. That order is under challenge in this court, in this petition. Under section 18, alternative remedy is there.
Of that order, my lord, as per the order, we have deposited 1 lakh.
sufficient. Section 18.
Section 18, my lords. Any order of DRT has to be challenged before DRT. It's an interim order and not complied. And even now, in the present case also, interim order is not complied.
Where is the order of the DRT?
Oh, my lord, in page number,
What is this, madam? You are abusing the process of the court.
no, my lord,
Why didn't you go before the DRAT?
my lord, only if,
No, no,
for,
don't-
for time being, my
No,
lord,
no,
4
no.
weeks, my
Don't
lord.
argue like that, madam. This is a court of law.
Please,
I am not going to entertain these kinds of submission.
please.
When there's an appeal under the DRA, before the DRAT, how did you come here? Where is the order of the DRT?
Annexure J, my lord, page number 51.
There is a complete abuse of process of court by entertaining such writ petitions.
Page number 53, the order portion, my lord.
So why did you come here then? So
Even this court
deposit-
order is not complied. My lords.
No, that's okay. Deposit is relating to what as per page 53?
Related loan dues, my lords. Whatever loan dues we had, position notice was under challenge. The section 14 order was under challenge, my lords, before
Section
DRT
14 order is challenged. The order is in page number 44, my lord.
for taking physical possession of the property. That was under challenge before DRT.
I supposed to deposit 8,40,000 on or before 5/4, my lord. I have complied partly, and after that I filed an application for extension. That application is dismissed. On that basis, I have approached this honorable court.
That I can't do anything, but you have not complied with the interim order. This practice of converting the High Court to a DRT, I am not going to follow. You have to go there. There is a statute. The present petition has been filed. Seeking for setting aside of the order at annexure J dated 9/4/2025. Full stop. By virtue of the order at annexure J, the debt recovery tribunal has vacated the interim order. Full stop. IA 272 of 2025 was allowed, subject to condition that the petitioner would pay amounts mentioned in the order dated 5/2/2025 within the stipulated period. Full stop. The tribunal, taking note of non-fulfillment of the condition imposed while allowing IA 272 of 2025, has vacated the interim order. Full stop. Said order has been challenged before this court. The counsel for the respondent bank has rightly pointed out that as against the order of the DRT under section 18, an appeal lies against the order of the debts recovery tribunal before the DRAT. Full stop. Next. This court, by order dated 29/4/2025, had granted an interim order subject to the condition that petitioner would pay 7 lakh to the respondent bank. Counsel for the respondent bank submits that said condition has not been complied with.
My lord, 1 lakh I have deposited, my lord. Fully I have not complied.
Petitioner has paid only 1 lakh.
1 lakh.
Next, taking note that the order of the DRT can be challenged under the provisions of the SURFACI Act in terms of section 18. And when a special procedure is provided, there is no warrant to intervene in the said proceedings in exercise of writ jurisdiction. Accordingly, petition is dismissed. Contentions of the petitioner are kept open to be raised in appropriate proceedings. Yes.
19,
Here on behalf of the
PN.
So this matter pertains to Sandur bypass, my lord, which we had constructed. My lord, the government and there was an understanding
government. Yes,
where, my
government.
lord,
Yes,
I will secure instructions in this matter.
find out,
Because regarding the payment.
find out.
my lord, may I just make this submission?
Well, let us
This
see,
may
let
not be
him-
very strictly adversarial in so far as the government is concerned.
So let him find out,
Yes.
find out and take his stand. There ends the matter.
Yes, my lord. Why I'm only making this submission is twice they have taken time. Let them, my lord, it's only with regard to that amount. Even indisputably also 85 lakhs they have to pay.
They're ready to reduce, they've shown
My lord,
some, they've shown some concession. Now you examine it and you take a stand. When do you want it?
A week's time may be great.
Relist the matter in the same stage on. This one.
Well,
Whatever obligation you have to comply.
Yes, sir.
Yes.
please, oblige.
20,
Manjuna, one నిమిషం, Manjuna.
Point number 3 in this.
One నిమిషం. Yes.
20, first one done.
I'm appealing for respondent number 3 in this
Yeah,
case.
20. 20, no? Yes, what is your stand?
That's right.
Government,
Government, yes.
next week it will be posted, my lord. I'll take instructions from the department and
No,
next
no.
Monday.
What is the allegation?
And
That every time you have been dropping the tender. So what is the position now?
we have, as of now, they are not issued it, my lord. Next, it may be posted next Monday.
Contention is that time is over for
Please, my
validity of the bid.
I'll take the updates, recent developments, and it may be posted on Monday. I will submit, my lord.
Next week date. Could.
Yes.
No representation for the petitioner. Date could next week. Next time.
21,
Appeal for petition, my lord.
Yes. Once action must be taken,
Please.
unless you say, what has happened now?
My lord, now they have arrested accused number 2 and 3 on 31st of May, my lord.
You have registered an FIR.
Yes, my lord. Their grievance is
F-
that, my lord, the
F- FIR
investigation
was-
is not complete and they have not filed the charge sheet from 3 years.
More than 3 years, my lord. I've been running from pillar to post. FIR is registered in the year 2023. Every time I go to police station, my lord, they're forcing me to compromise with the accused. Take the money, whatever they give. Now, I only requested that let there be an investigation for 3 years. 27 lakhs I have lost.
No,
And-
just one.
Please,
Now you just have a go through a judgment
please,
passed by me, I think last year,
please.
setting suggestions for completing investigation and filing charge sheet.
Please,
You bring that judgment,
please,
we will issue some direction.
please, I'll get it.
We have dealt with the delays in investigation
Please,
and given some guideline.
please,
You take it from the court officer.
please,
It's only a guideline we have given,
please.
and then let us see. Now, when have you filed the charge sheet now?
No, they have not
Charge sheet
filed.
is not yet filed, my lord.
Ah.
What they are, my oral instructions are that, my lord, as they were not arrested the accused persons, my lord, they could not complete the investigation.
You
As
put it-
now they have arrested accused number 2 and 3, it is showing that there is a involvement of some other person. So they may require some more time to complete the investigation
That
and
you
file
put,
the charge.
you put it in writing,
Yes, my lord, I'll file.
and then we'll see, have a look at that
Please,
judgment.
I'll,
Publish.
Week after next date.
please, please. Grateful, grateful.
22,
For the petitioner, madam. Petitioner challenge sale notice before this honorable court. On 28th February, this honorable court passed an order, my lord. It's on page 112.
Who appears for the bank?
I beg to appear on behalf of my
They
lord.
have paid the entire amount now, my lord. This order was later clarified by my lord. 28th February order said I have to pay 2 crore 55 lakhs, solatium and interest to the auction purchaser. Now, my lord, what happened was, this was on 28th February, by annexure A.
Yes, what do you say, bank, what do you say?
My lord, what had happened in this matter, my lord? My lord, petitioner, my lord, filed the various writ petition before this honorable court. I said, my lord, my surface measures. This honorable court, my lord, passes some conditional order. My lord, in page number, my lord, I'll just point out the order passed by this honorable court, page 111. Wherein, my lord, the sale notice at my lord 111, annexure P. We have fixed the, my lord, sale on my lord 15/11/2024, indicate that sale will be taken place on my lord 4/12/2024 for recovery of rupees my lord 3 crore 24 lakh. Wherein we successfully conducted a sale. Subsequent to that, my lord, this honorable court pass an order at my lord page number 112. At my lord page number 115, my lord, is operative portion of the order. I'll
Para 7.
also.
Yes.
Before that, my lord, I'll point out, my lord, para 4 also, para 3 also, my lord, at page number 114. Learned counsel for the respondent, however, submits that auction was held on 2/12/2024, and if the sale was confirmed in favor of the auction purchaser, it is submitted that this is a fourth writ petition filed by the petition, and the petition did not fully comply the directions issued by this court. The previous writ petitions, learned counsel would submit that although it true that the petition deposited 82 lakhs on 26/12/2024, nevertheless, the outstanding amount as on the date when the auction held was rupees 3 crore 24 lakh 81,479. It is further submitted that even the amount deposited by the petitioner, that is 82 lakh, is taken into consideration. Nevertheless, the outstanding amount due would be more than so and so, 2 crore 55 lakh. Learned counsel for the petition submits that if 4 weeks time is granted, the petitioner will deposit the entire amount of 2 crore 55 lakh along with the accrued interest. Learned counsel respond would further submit the writ petition can be disposed of by permitting the petitioner to deposit the said amount within a period of 4 weeks, failing which the respondent may permit it to proceed with the sale certificate in favor of the auction purchaser. IA number so and so allowed, and consequently the writ petition stand disposed of, permitting the petitioner to deposit rupees 2 crore 55 lakh along with the accrued interest and solution in favor of the auction purchaser. My lord, what had happened, my lord, subsequent to that, my lord, they are not paid the complete money. We issued the sale certificate in favor of the auction purchaser.
Now, is the auction purchaser made a party?
No, my lord, I was not aware of it when the writ petition was filed.
Now you make him a party.
Yes, my lord.
And in law, you know where you stand.
My lord, I understand. Ordinary circumstance, I could not have. No, my lord, what had happened was.
Now let us see, you make him a party.
My lord, there is a subsequent order by this honorable court. I will just point out, I will go down to what your lordship said. This honorable court on the 18th of April clarified and said that all earlier payment that I have made have to be taken into account by the bank. That order is here, my lord. It was not available at the time of filing.
No, that may be so.
And I have paid the entire amount also.
So maybe so. But where in law, what is the position of the auction purchase?
I agree, my lord. I understand that. In view of this 28th February order, I will make the auction purchaser party. My submission is, my lord, in this case particularly, auction admittedly was scheduled on 4th of December. They have conducted the auction on 2nd of December. I had challenged there. I had benefit of an interim order in this honorable court in the earlier petition.
So you make the auction purchaser.
I'll make my lord. In the meanwhile, my lord, let them not register sale certificate in favor of auction purchaser, because, my lord, my problem is.
You tell me in Bafna's case.
My lord, I agree. I cannot otherwise, but my lord, by virtue of the order of this honorable court, if your lordship sees the order dated 28th February passed by this honorable court,
pass an order unless you implead that.
Well, I will implead, my lord. All I am saying is let bank not register the sales certificate in their favor, my lord.
That would be contrary to Bafna's case. I am not going to pass an order.
My lord, I agree, normal scenario, but if 28th February order of this court is seen.
Supreme Court has said, what has it said? You lose your right of redemption.
I agree, my lord. All I am saying is 28th February, in view of 28th February order of this.
How can the Supreme Court or you? How can we go against the order of the?
My lord, I am not on the precedent part of it, my lord. That is on the merits of the case.
Not on the merits, sir. I can't pass an order.
My lord, I agree. In case of in the event of a valid auction being there, I agree, my lord. If 4th December was the date of auction, if 2nd December auction is set, and my lord, 11 crores is the valuation.
I am not going to enter into that. You point out from Bafna's case whether your right of redemption is open. If it's open, I will consider.
My lord, I agree in the normal scenario, but if there is a certificate issued contrary to the order passed by this honorable court,
Now you point out from the discussion in Bafna's case, if there's a way out, I will go through it carefully. If there's a way out which says that the auction is void, court can interfere, I will have a look at it. Otherwise, I can't restrain.
My lord, I agree, my lord. In normal scenario, I agree. All I'm saying is, my lord, a property valued by the bank
But in
at
fact, my
11
lord,
crore.
the borrower
is-
also paid the entire money, auction price also paid the entire money. Pursuant to that, I issued a sales certificate.
And within 4 weeks from the date of modification of the order,
Sales certificate I issued in favor of the auction purchase.
I have issued, my lord.
My
Therefore,
knowledge
I'm
is, my
saying,
lord, it is not got registered because registration, I don't have any role, my lord. Auction purchase has to go to sub-register officer and he has to get it registered. We'll go give only exemption which you are given.
therefore, I'm asking an interim production in the meanwhile, my lord. I will array auction purchaser as a party.
If I can only say anything, take any action done would be subject to orders to be passed. You make him a party.
Yes, my lord, I will do that. Yes,
You have no case counsel.
my lord, I will try to convince my
Let
son
us
of-
see. Let us see.
I'll try my best, my lord. I have.
The counsel for the respondent bank submits that sale certificate has been issued.
Please, my lord.
Full stop. Petitioner to complete the auction purchaser.
Let them furnish the
I'll furnish the details. I'll furnish the details.
Details
My
will
11
furnish,
into
my
dates.
Full stop. Details of the auction purchaser to be furnished to the petitioner within 2 days from today. Otherwise, I'll pass over. You give him the details.
I'll furnish.
I'll pass over.
Yes, my lord.
Great.
I'll permit you to implead. You take out notice.
Yes, my lord. I'll do that.
Or I'll have it tomorrow. You give him the details. Let him
Have it tomorrow, my lord. I take
Yeah.
instructions.
Yes, my lord. I'll make application also tomorrow itself.
relist tomorrow.
Great.
But counsel, you just take it from me that I am not going to go against what Supreme Court has held.
My lord,
So
I cannot
you-
argue that also, my lord. I cannot argue that. I will have to try to convince this honorable court.
From Bafna's case, if there is any way open, you make out.
Yes, my lord. I will, my lord, at least any action by the bank may be subject to outcome hereafter at least. Your lord.
First implead him. Let us see.
I will.
Yes,
23.
relist tomorrow.
Petition is a agriculturist. The respondents accept the
They are a FFPO, the Fisherman Fishing Production Company, not the farmers. My lord, what has happened is, as per the fishing policy of the state, which is passed in 2014, the ponds, lakes, reservoirs, and the live rivers, my lord, have been classified. And what has happened is, who can apply? My lord, Hobli Mattado, Hobli level ponds and river, and also district level and Zilla Panchayat level, my lord, then the auctions have to be called for. Now, my lord, one of the requirement of the FPO was that they have to have minimum balance for the lease amount that they have to pay to the state every time. There, my lord, they don't even have, they have not maintained. And that's why, my lord, the idea is to develop the fishery in the water bodies. My lord, that is why the Annexure D has been issued. My lord, they are challenging that. They have to come before the court and they have to show their bona fides that they are fulfilling the conditions of the lease, my lord.
already granted intermodal manner. Your last minute, kindly see minute.
No.
Minute, you accept minute 1,32,000 minute, 1,32,000. Minute now minute denial of minute fishing rights.
No, they are required to give a skill test.
Yes, ma'am.
Yes,
So
That has been stayed.
So they're required to give a skill test because they're not fishermen. Well, what happens is, if you are in a cooperative society of that Hobli or the village, then the similar community or the persons who are involved in the fishing activities are the members of that society. Now, what had happened is, in the policy, my lord, they include the FFPO, that is a fishermen fishlings production organizations. That could be a company, LLP, whatever involved. That is where, my lord, there what has happened is they have got a farmer certificate and they have formed it. Well, now for these such people, we have said there should be a skill test to show that they are involved in fisheries.
now, why are you hesitating to take the skill test?
Minute, you are like already stayed minute. Totally. Stay has been granted. You are like in the above, in the said circumstances, the respondent herein are directed to not to take any coercive steps against the petition by insist undergo a skill test till next date of hearing.
My lord, the skill test is in their interest, my
No,
lord.
no, on what ground you are asking for interim order?
My lord, yes, my lord. ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ಕಿಲ್ ಟೆಸ್ಟ್
So do the skill test now.
ಆಲ್ರೆಡಿ ಅಕ್ಸೆಪ್ಟ್ ದ ಮನಿ 1,32,000.
Council, please
ಆ
look at
ಸ್ಕಿಲ್ ಟೆಸ್ಟ್ ಅಂದ್ರೆ ಏನ್ ಅನ್ನೋದೇ ಗೊತ್ತಿಲ್ಲ.
that you do find out now.
ಅಲ್ಲ ಯು ಆರ್ ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಎರರ್ ಮೇಡಮ್, ಯು ಆರ್ ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಲ್ಲಿಗಲ್.
Why do you say it's illegal? What is the ground for you to challenge that condition? Once you participate in the proceedings, you are bound by whatever restriction they have imposed.
As per the policy, my lord, that is there in the policy.
ಅಲ್ಲ ಎಲ್ಲಿದೆ ಪಾಲಿಸಿ, ಎಲ್ಲಿದೆ ಏನೂ ಇಲ್ಲ. ಇವರಾಗಿ ಇವರೇ ಸ್ಯೂಮೋಟ ಮಾಡ್ಕೊಳ್ಳೋದು ಎಲ್ಲಿದೆ?
I will produce the policy, my lord.
ರೆಗ್ಯುಲೇಷನ್ ಎಲ್ಲಿದೆ?
At request on behalf of the government, state, relist the matter on date code. The state to place on record the policy relating which
So the fishing policy.
mandates skill test for the purpose of grant of lease pursuant to which annexure D has been passed.
Grateful.
Release the matter on
12.
12th. Yes.
Grateful.
ಮೇನ್ ಟೈಮ್ ಮೇಡಮ್
No, let us see.
ಆಲ್ರೆಡಿ ಗ್ರಾಂಟೆಡ್ ಮೇಡಮ್.
No,
Your
let us
last
see.
minute, stay already granted.
Not in this matter.
No, madam?
We have not granted a stay.
No. Other case.
I'll consider on the next.
Other case.
I'll consider on the next date. Yes.
24, Girish R.
Parole application.
Lord, in this case also, my lord, the bail applications are
application.
pending,
Same date. When is that?
date may be given.
When is that matter posted?
16,
6.
Relist on 16th.
25, Girish.
Same parole application, madam. Lord,
So on
this
what
matter, my
ground?
lord, he is seeking parole on the ground of house renovation. He is involved in a POCSO matter. He is 27-year-old and his conviction came only in the year 2024. He has been in the prison only for a year, my lord. And on same ground, my lord, even the report was obtained and that has been rejected. The offense is POCSO, my lord.
House renovation cannot be a ground for parole.
His father is there.
I will convince the court, my lord, 16th.
But there are in several cases where, my lord, if there are no other respondents, if there are no other people to take care, his father has come before the court. He himself can renovate the house. It is not that the accused has to go and renovate the house. Above all, my lord, it's sensitive offences that they are involved in POCSO, and he has not completed 2 years period also.
You place whatever authority you have, let us see.
Grateful.
Release the matter on date code. POCSO, whatever the offense, parole cannot be granted
As a matter
at the mere asking. You have to make out some illness, death, etc. Not for such grounds. Yes.
26, Girish.
Same, my lord, parole application, my lord. Same parole application.
Huh?
It's also parole.
What is the ground? What is the ground made out now?
He is a custody in 3 years, 3 months, my lord.
No. What is the ground for seeking parole?
Was home renovation, my lord.
All these cannot be a ground. You convince, same date code.
16,
If there is any judgment relating to the guideline for issue of parole, you place it on record. Yes.
27, still number 27, the Edelstone KV.
Yes.
This case appear for petition, my lord.
Yes.
Annexure A, page number 18 is the impugned order, my lord, issued by the third respondent, Karnataka State Financial Corporation, my lord. The said corporation is going to sell the assets by releasing the paper advertisement, my lord. He has not given any mortgaged any assets, my lord. He has mortgaged the property, my lord.
You serve on the council. KSFC.
BV Chandrasekhar appears for KSFC.
KSFC.
BV Patil also appears. BV Chandrasekhar appears.
PV Chandrasekhar appear ಆಗ್ತದೆ. KDB ಗೂ ಅವರೇ.
KDB served, my lord.
Lord
Sir.
Counsel Shri PV Chandrasekhar is directed to accept notice for response 1 to 3. Relist the matter in the orders list on 9. You serve on him. If there's an alternative remedy, I'm not going to interfere. Yes.
Respond number 3 ಯಾರು? Advocate.
You serve on the council.
ಚಂದ್ರಶೇಖರ್. 3 ಜನಕ್ಕೂ. ಅಲ್ಲ. Respond number 3, there is some other advocate.
He appears for the KSFC also is
Please.
what I've been told.
Please.
But you take it from me, if there's an alternative remedy, I'm not going to interfere. You will have to go under the scheme. Yes.
28.
I'm appealing for the petitioner, my lord. Here petitioner is a successful bidder and he requesting for the sale certificate in the favor of petitioner, my lord. But even the sale certificate is not providing from the investing company.
Who appears for the bank?
ಇದಾರೆ.
Bank nodu Cholamandalam.
Bank Cholamandalam.
Is there any standing counsel for the bank? You find out. You find out if there is a standing counsel and we'll.
But we have paid all the money, my lord.
So let's find out. Now you take out emergent notice to 2 to 4. 2 to 4 you take out emergent notice. Emergent notice to respondents 1 to 4.
Kindly grant
Petitioner
for
is
the-
permitted to serve notice by way of hand summons as well and serve the standing counsel for R1. List the matter on. Will you take out hand summons to 3 to 4?
No, my lord, I will.
Okay,
pay-
one at least you take out. You serve the standing counsel for 1. Ali, hand summons to the first respondent. Emergent notice to 2 to 4. List the matter in the orders list. Date code. 12th.
Bless me.
29. Vinay Kirtiyam, Vignesh Shetty.
Here for the petitioner. In this matter, your lordship, you are not able to comply with the interim order. I pray 1 week time to that, your lordship.
Lord, I would like to point out one or two things. The petitioner, my lord,
Just wonder, what is the interim order passed?
That your lordship, I had to deposit a 20% within 4 weeks. 4 weeks completes on 28th itself.
my lord, instead of complying that order, he filed one more writ petition.
Which is a
My lord, in writ petition number 13201, my lord, the petitioner assailed the section 14 order before this honorable court. This honorable court granted interim order on my lord 28/4/2025, saying that 30% of the money which he is supposed to pay is not paid anything. And he filed one more writ petition, that is 15460 of 2025. My lord, one communication I issued in pursuant to the interim order, my lord, which is not complied. That is 15460 of 2025. My lord, all I'm saying, my lord, first and foremost, my lord, is not complied the interim order. And second thing, my lord, this alternate remedy under section 17 before the DRT. Within 45 days from the order, my lord, you would have
I'll
won.
have both tomorrow, we'll dispose it.
Grateful.
List along with WP 15460 of 2025 in the preliminary hearing list tomorrow.
Grateful.
These are all matters wherein nobody is interested except getting an interim order. Your client cannot comply. What is the purpose of getting such interim orders? I am not going to intervene in these matters. Yes.
30. Still number 30.
As for the petitioner, my lords. My lords, the petitioner is carrying a legal business obtaining by a lawful license.
You have complied with all.
Yes, my lord. I've also served to the,
Yes. What is the matter?
my lords, GM police, my lords. It's where the police have been constantly interfering with my business, my lords, from day to day activities. They're not letting me to carry out my business. And there is covered by judgments that I have.
I'll take instructions in this regard.
Now you find out.
I'll take instructions.
AGA submits that they would obtain necessary instructions regarding the relief sought for. Relist the matter on
Any-
12th.
It could be.
But
These matters, what orders, madam? This is all settled position. Nobody is going to interfere unless there is any illegality. So
But
these
every-
writs, when I was a lawyer also, I filed. Even now it's being filed. If there's any illegality, they will interfere. Otherwise, they will not. Unless you say,
Yes, my lord.
unless you say that they have been asking you to pay some amount every month.
That-
You place it on affidavit, I will take action.
Yes, my lord.
I will order for the suspension. There's no hafta vasuli in all these kind of thing. If the police are at fault, but you must come forward and put it on affidavit, I will grant all, whatever you want, I will grant. You
Yes.
place it on affidavit.
I will, my lord. Much obliged.
Well,
31.
Your Lordship, in this matter, the complainant and the petitioner herein, it's a civil dispute, my lord. However, the complainant herein, they filed a complaint before the respondent number 1, saying that we have criminal trespass. We have not received the copy of the complaint, and based on that, they've taken action. On to the first notice, I've already I had appeared before the respondent number 1, and I had also filed counter complaint. Despite that, despite showing them that there are civil disputes, a suit for partition and miscellaneous petition pending before the civil court, my lord, Bangalore, despite mentioning that they're harassing me, they come to my house and they keep asking for injunction order. And last week, my lord, we have got an injunction order as well to that effect. But these.
yes, you find out, madam.
I'll get instructions.
Get instruction. If it is whatever in accordance with law, you can take action.
My lord, an FIR has been registered, my lord. Accordingly, a notice has been issued to the petitioner.
My lordship, this is not the first instance. I had filed number of complaints before the same respondent. They have not taken any action to that effect, my lord.
No, your complaint is
My lord.
filed on 7/5/25.
Yes, my lord. Before that also, my lord. Kindly refer, my lord.
You find
Annexure.
out. Just wait. Annexure A.
Yes, my lord.
You find
I'll
out.
take instructions.
Deal is the matter in the
At least, my
preliminary
lord, not
hearing
to
list.
take any precipitative action.
No. What to precipitative? That you law, whatever law in law there, you do it. You want to challenge the validity of the FIR lodged against
FIR,
you,
they can.
go under 482 and you challenge it. Insofar as your complaint, let them find out. AGA accepts notice for the first respondent. Emergent notice to the second respondent. List week after next. Yes. You want to challenge the FIR against you, file 482. Yes.
32.
For the respondent status.
Petitioner, my lord.
Yes.
They issued writ of mandamus, my lord, directing the respondent fight 2 to file, my lord. They reconsider the voter list, my lord. Annexure F, my lord. Page number 80, my lord. The Bangalore South Club, my lord, list dead members.
How is the writ
Petitioner is alive, my lord.
how is the writ maintainable?
My lord.
Huh?
Any direction, my lord, the sixth
No.
respondent and fifth respondent colluded, my lord, prepare the voter list, my lord. You are a dead person, the petitioner is a list of dead members, my lord. Is a serial number 169, kindly, my lord, page number 81.
Under 25 before the district registrar. The complaint
He
was
is
used to go
allowed,
for the
the
district
petitioner is
registrar.
allowed, my lord. The sixth respondent and fifth respondent, fourth and sixth, fifth respondent is colluded, my lord, prepare the voter list, my lord.
No, what is the relief you are seeking?
Only direction, my lord, will be the press concern, press inquiry concern.
What direction you want? What is the direction you want?
To consider fresh voters list. Well,
The representation was submitted before the authority, my lord, but
Huh?
the representation submitted before the authority, my lord, but till today is not considered annexure D, my lord, page number 27, my lord. And 28, चुनाव संबंधी सदस्य अक्षर में दूर
Page 20.
page number 47, annexure D, my lord, representation submit on 22/5/2025, my lord. ಅನೇಕ ಲೋಪಗಳಿರೋದು ಇದನ್ನ ಮರುಪರಿಶೀಲನೆ ಮಾಡಿ ಬೇರೆ ಅಧಿಕಾರಿಗಳ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಎಲ್ಲಾ
You find out if under 25 any case is made out for you to consider. You take instruction.
Yes.
AG accepts notice for respondents. 1 to 6, 1 to 5. Emergent notice to respondent number 6. List a week after next.
33, Rajesh DS.
Petitioner, Your Lordship. This petition moved
Office
before the
objections,
vacation bench, Your Lordship.
What is the office objections? What is the office objections?
It may kindly be dispensed, it's simple in nature, Your Lordship.
What is the office
It
objection?
is for extension of parole.
What is the office objection raised?
Earlier, 2 times it was been posted. That time there was no any office objection. Now it is appearing as office objection.
Anyhow, that you comply. What is urgency now?
No urgency, Your Lordship. Today, the parole period is going to end. At Annexure A, page 7, he had applied for 90 days parole. 45 days was being granted. Today it's going to end. His mother still in critical condition as per Annexure D, the original medical certificate at page 13. Moreover, Your Lordship, he has already completed his 15 years of life sentence. He is no more required to be kept detained. His name is recommended to be released on Independence Day.
Yes, madam. What is the position?
My lord, till today he was on parole itself, my lord.
That is there.
That is
but-
by the order of this honorable court itself, my lord. Till 4/6/2025, my lord, he was granted parole, my lord.
It may kindly be extended, Your Lordship. Very much necessary.
So now you
It's number 10 of the petition.
correct. Now insofar as the final decision to be taken by the committee,
Yes, ma'am.
that you have to expedite. You can't keep it pending indefinitely.
I'll verify, my lord,
You
how much
verify
time is
that.
required.
We'll have it on the same day as that other matter.
Yes, 16.
The other Shaman's night.
16.
Until then, it may extend it,
Huh?
Your Lordship.
We'll extend this parole
Please, ma'am.
on the same conditions.
On the same grounds.
On same. It is the case of the petitioner that he has served his sentence of in custody for 15 years.
Yes, nearly 15 years.
For nearly 15 years. And his name has been recommended for remission to the advisory board
Yes, yes. For Independence Day.
for premature release, taking note of his conduct. Full stop. Further submitted that advisory board has not taken a decision till date. Full stop. Peruse the order dated 17th April 2025, passed in WP 8563 of 2025. The operative portion of the order reads as follows. Page 4 and 5, extract money. Full stop. It is submitted that till date no decision has been taken on his pending application. AGS submits that they would take necessary instructions regarding the proceedings before the advisory board.
Yes, ma'am.
Accordingly, on same terms and conditions as extracted above, as contained in the order passed in WP 8563 of 2025, parole granted is extended by a further period of, shall we extend for how much time now?
90 days, Your Lordship.
I'll verify, my lord, how much time is required for them.
30 days.
At least 60 days, Your Lordship. Independence Day has to come.
By 30 days. Full stop. Matter would be the AGA to obtain any necessary instructions by the next date. Full stop. Matter would be kept pending, considering that the application of the petitioner before the advisory committee requires to be looked into and decision taken. Full stop. Copy of the order also to be communicated to the Member Secretary Legal Services Authority to intervene and take necessary steps if the guidelines laid down regarding remission have been complied with, and to ensure genuine cases be proceeded with before the advisory committee. Relist the matter week after next. Date kodu. Avatiga kodu. 16.
Obliged.
34, Vinod Kumar.
My lord, externment proceedings, my lord. My lord, they have pasted the notice in my residence without containing the report, my lord. Lordship may kindly see this honorable court. In similar circumstances has held that, my lord, the notice should contain details of the case, details of the evidence, and the documents and annexed with it, my lord. Without that, my lord, they merely pasted in my residence, my lord. Covered by this honorable court's judgment, my lord. Judgment, your lordship may kindly see at page number, my lord, 31, my lord. 31, the notice has been quashed merely because it does not contain.
On what ground are they seeking
My lord,
to
the
pass
notice,
an order against you?
they are saying ನಿಮ್ಮ ಮೇಲೆ ನೀವು ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಗಲಾಟೆ ಮಾಡೋ ಸಾಧ್ಯತೆ ಇದೆ. Page, my lord, 29, my lord. My lord, he is a Gram Panchayat, 3 times Gram Panchayat member, future candidate for Jilla Panchayat member. Therefore, they are there. Your lordship, kindly see 29, my lord. 29 ಅಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಸಾರ್ವಜನಿಕ ಸ್ಥಳಗಳಲ್ಲಿ ಮತ್ತು ಗ್ರಾಮದಲ್ಲಿ ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಗಲಾಟೆ ಮಾಡುವುದು ಮತ್ತು ತನ್ನ ಸಹಚರರಿಗೆ ಸೇರಿಕೊಂಡು ಬೆದರಿಕೆ ಹಾಕುವುದು ಸಾರ್ವಜನಿಕರ ಆಸ್ತಿ ಪಾಸ್ತಿಗೆ ನಷ್ಟ ಉಂಟು ಮಾಡುತ್ತಿದ್ದು ಈ ತನ್ನ ಚಟುವಟಿಕೆ ಆದ್ರಿಂದ
Police Act, Section 50, Police Act.
55.
Section 55.
My lord, 55A and B, my lord. 55 Karnataka Police Act. Removal of, may I read, my lord?
Yes.
Removal of persons about to commit offences whenever it shall appear in the city of Bangalore and other areas for which the commissioner has been appointed under section 7 to the commissioner, and in other areas to which the government may by notification in the official gazette extend the provision of this section to the district magistrate or the subdivisional magistrate having jurisdiction and especially empowered by the government, that the movements or acts of any person are causing or calculated to cause alarm, danger or harm to person or property. B, my lord, that there are reasonable grounds for believing that such person is engaged or is about to be engaged in the commission of an offense involving force or violence or in an offense punishable under chapter 12, 16 and 17 of the IPC, or in any abatement of any such offense, and when in the opinion of the such officer witnesses are not willing to come forward to give evidence in public against such person by reason of apprehension of their part as regards the safety of their person or property. Witness get threat kododu. My lord, he is a panchayat member from 3 times, my lord, and your lordship, there is no activities which is endanger that he should be externed from that place. ಅಲ್ಲಿಂದ ಗಡಿಪಾರು ಮಾಡಬೇಕಂತಂದ್ರೆ ಯಾವುದೇ ಇದಾಗ್ತದೆ. Lordship, similar circumstances, your lordship may kindly see, my lord, page number 83, my lord, 33, the judgment of coordinate bench, my lord, wherein it says, my lord, 33, your lordship, para number 4, my lord, the impugned so-called notice has been stayed by this court, primarily on the ground that the required report which forms the foundation of such notice was not appended. thereby violating the crucial procedural requirement under law. The absence of such a report renders the issuance of the show cause notice legally unsustainable. Further, another judgment, my lord, of coordinate bench, your lordship may kindly find at page number 39, my lord. 39.
Report is required under
Yes,
section
my lord. Yes, my lord. Report is,
55.
yes, ma'am. It should append.
Now you place it on record, madam. What is the ground?
Yes, ma'am.
Now, if there is something, you must at least mention. Now it's a very vague notice that is issued.
Lordship, may kindly see page number 39, my lord.
Page?
The 39, my lord. The judgment of the coordinate bench, my lord. Wherein, para number 8, 39, my lord.
Yes.
Yes, para number 8. In the present case, show cause notice does not provide the particulars of the alleged criminal cases registered against the petitioner, nor was the police report which resulted in issuing the show cause notice contemplating action under 55 of the act forwarded to the petitioner, so far to enable him to give suitable reply to the show cause notice. Further, a reading of section 58 make it clear that the authorized officer shall inform the person as against whom action is proposed under section 55, 54, so and so act in writing of the general nature of the material allegation against him and give him a reasonable opportunity to tendering an explanation. In the present case, it is not lacking. Thereafter, my lord, 11 Ali.
I'll obtain that report, my lord, what they have submitted. I'll obtain that.
No, the note further not given opportunity to defend his case. The material allegation made against him is not reflected in the show cause notice issued him, nor was the copy of report of the police based on which action was provided under 55 of the act was contemplated was forwarded to the petitioner. Further, in pair number 12, it says the petitioner has not been convicted. I am not been convicted, my lord.
So we can do one thing. We'll keep it pending. You will not pass an order unless you furnish to him the material, and then let him reply. You consider it, and then we can keep it open. We can dispose it of. They will not pass an order
Yes,
without hearing you and without furnishing a report. Or you place it on record. Let us see. I'll have it next week. No final orders to be passed.
till then, not.
And the counsel for the petitioner submits that the order of externment is sought to be passed on a notice which does not set out grounds of grounds on the basis of which proceedings are sought to be initiated against him. It is further submitted that police report on the basis of which such notice is sought to be issued has not been communicated to him. Full stop. In light of the same, there would be stay of proceedings further to annexure J till the next date. Respondent state to place on record material on the basis of which notice at annexure J has been issued. Relist the matter on
Next weekend.
date code 17th.
Much of.
Yes. Now, if suppose you are going to seek for externment, the notice must indicate that he is going to, there is a possibility of him involving in some communal clash or in some action which is going to be a law and order problem. Otherwise, it's very cryptic where you don't put him to a notice and he cannot defend his case. Yes.
Much of.
35, Sundaresh ji.
Week's time granted to take out steps to R6.
36.
Office to put up report regarding notice to R5. Yavdu? Which matter?
36. 36, Badrinath.
Office to put up report regarding notice issued to R3 and R4. Interim order earlier granted is extended till the What is this matter?
The senior citizen act.
Yeah. Earlier, the earlier protection granted as per order dated 23/4/2025 is extended till the next date, this week after next.
For the respondent number 1, Your Lordship. The petitioner had undertaken that they'll withdraw this petition, Your Honor, because it's infractuous. That filed this petition to obtain a stay order, Your Honor, against the proceedings of an auction under SURFACE Act, but the auction was conducted, Your Honor.
Was conducted.
Was conducted. The stay order was not granted to them during the previous hearing. They had filed another petition wherein they undertook that they'll withdraw this petition.
Now, on what ground he has challenged?
I appeal for SBI, Your Honor.
He has challenged on what ground?
EMCC, that we didn't name them in our auction notification, Your Honor. But the same auction was allowed and it was conducted also. Your Honor. They hold the second charge, Your Honor, that was not mentioned in the notification, auction notification. But the auction was allowed to be conducted.
Are your dues satisfied?
Your Honor, Your Lordship.
Are your dues satisfied?
Yes, Your Lordship.
Correct. So, is there any amount remaining?
No. The auction was failed, Your Honor. No bidders. 120 crores is the first charge held by SBI and Canada Bank, Your Honor. Consortium of SBI and Canada. They hold the second charge of 12 crores, Your Honor. The auction was failed, Your Honor. No bidders. And we conducted an auction, second auction also. No bidders, Your Lordship.
So, since the e-auction has already been conducted and there are no bidders,
No bidders.
so for present this goes.
Yes.
His contention can be kept open.
Please, Your Lordship.
You file a memo.
Please, Your
File a
Lordship.
memo. Counsel for the respondent number 1.
Number 1, Your Lordship.
Bank submits that the relief sought for does not survive for consideration as the auction was conducted and there were no successful bidders
Please.
which could have been taken note of. Full stop. Further submitted that fresh proceedings would be taken by the bank as per law. Full stop. In light of such stand, the petition is disposed of as not calling for any adjudication. Legal contentions are kept open.
Please, Your Lordship.
38, Nagarajappa.
Comply the office objection.
However,
2 weeks may be granted.
alternative efficacious remedy is there. It is an order under 64A. It has to be challenged before 64A3, man, before approaching this court.
That has been examined, that alternative remedy will not come into picture, my lord. We have already exhausted.
If your lordship will kindly see the annexure produced by them at page 77.
64 of
64A of the Forest Act, my lord.
Good.
Order has been passed, the 64A. That is under challenge here. Annexure D, page 51.
Page
51, my lord.
So this is an order relating to
The
Sorry,
eviction
eviction.
of an unauthorized occupant of a reserved forest. The
Eviction
notified
from
state
the, my
forest.
lord, the lands in question, it is land was granted. Man regularized and granted long back, issued Sagwali chit.
My lord, that cannot be a ground before this court, my lord, because.
Let him file his
The apex
objection.
court in Nirvana
He
Gowda
cannot
has said
stay, my lord,
revenue-
extempore, I have
revenue
not complied the
revenue-
office objection.
Revenue entered in
no, correct.
motivate-
Against this order under 64A,
Yes, my lord.
appeal
Appealable order.
lies under
64A3, man. Any person agreed by the order of the forest officer under subsection 1 may within such period and.
just 1 minute. Just
64A3, man.
They have already approached, that has been a question of 64.
no, this is an order under 64A.
Yes, my lord.
Which subsection? The pre.
1, 64A,
One.
1.
What is the procedure for filing an appeal? How much time is the rules are there or what is the?
There is one.
But my lord, the order, my lord, the impugned is passed by, my lord, Sahayaka Aranya Samrakshana. It's not an order passed by, my lord, an officer as required under 64A. Your lordship, kindly similar to the caption.
Assistant Conservator of Forest is the one who has passed the order.
But an appeal lies to a forest officer.
He is the forest officer.
Who is a forest officer under the act?
As per the Forest Act, my lord.
Now let them find out. Now in case there is a provision,
Yes, sir.
then you can go there.
Yes, sir. My lord, in fact, if your lordship.
My lord, I have examined all the, my lord, the provisions. There afterwards, I prepared a writ petition.
So let
Why
us
should I
see.
shirk my responsibility?
No, correct. What we are saying, under 64A,
I will examine and I will make.
His own document, my lord. For a moment, my lord.
no, let him find out. You also find
Don't
out
have any book at.
who is the,
The page
My lord, you don't have a forest act. How can you argue, my lord, without holding a book?
under section 2(6).
Let my friend not be worried about that, my lord.
Leave it, will. Under section 2(6),
Yes, sir.
He cannot argue
just
extemporally without holding
find
a
out
book.
is
You are a
any
government
person
advocate.
notified.
Yes, sir.
Is there any authority who is notified?
Yes, ma'am.
And then
But I will examine and I will place it before your lordships. I am not a.
have it next week.
But give me, my lord, 2 weeks. I have to comply after
My
the
lord,
objection.
page 77, his own endorsement, which he has produced in the writ papers, says that you have not
File your
exhausted his
objection,
remedy.
sir. You file your detailed
Endorsement is
objection.
issued.
It has listed for
My
compliance of
senior friend
office
should not make
objection.
such kind of allegations, my lord, unnecessarily. His own document says so. 77, my lord. Your lordship,
What
kindly
is the
see.
allegation, sir? You are a government advocate. You should have, my lord, hold a statute book.
It's here, my lord. My learned
Office
friend wants.
objections
The entire
to
statute
be
is here on my
complied with
laptop.
the
I can ask.
Not the way. We have also conducted
petitioner
case.
to point out regarding the non-availing of alternative remedy under 63A
3.
3
A3.
relist
Not
on
63, 64A is.
64A3 relist on
My lord, week after, because I have to comply other officers.
week
2 weeks,
after
your
next. Office objections to be complied in the interregnum.
lordship. What has happened, my lord, the laptop nalli ಈಗೆಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಯಾರು ಬುಕ್ ಹಿಡ್ಕೊಂಡು ಬರೋದೇ ಇಲ್ಲ. This is become a fashion.
Yes.
As if it is everything available in the laptop.
39. Appear for the.
Yes.
In the connected matter, the challenge, my lord, in this petition. Please.
Lord, in the connected matter, I am told that both the petition involves the same land. And I was just seeing, my lord, on the last occasion also, I made a request for my friend to give a copy. Today he has given me now. May I request for shortest accommodation, my lord? So that I'll go through his writ petition also. So that I can make a request.
No, let us see. Now, what is the matter?
My lord, Annexure C, my lord, notification is called in question, by the virtue of which, my lord, invoking section 23 of the Act, my lord, a declaration is made to declare the private temple, which belongs to the petitioners, my lord, as a notified institution. No hearing, my lord, no notice. Directly, my lord,
Annexure C.
Annexure C, please, my lord.
But this is of the year 2012.
My lord, there was no notice whatsoever to me. I was not put on notice. My lord, suddenly one fine day, my lord, before my temple, my lord, the board was put up. Then, my lord, I got to know I make an application. Annexure C, my lord, some other name, my lord, was given. It's stated as Kingur, whereas, my lord, the present one is Kirangur. And we were never, my lord, we are totally kept in dark. My lord, everyday affairs, my lord, are taken care of by us. There were pending litigations against private persons. We were fighting it. We were successful. We have been throughout, my lord, protecting. We are in possession of the property as its absolute owners. having got it under the land tribunal order. These thing, my lord, is to put us on notice, which they do not do.
Yes, now the state,
But we have filed statement of objection. But after the 1997 Act has come into force, as required by the Act, my lord, this notification issued. Earlier also, it is a notified institution, but we have produced Annexure R1 along with our statement of objection. Statement of objection is filed on 9/8/2024. Under the earlier Act, old Act. At page 10 minutes, Annexure R1. This notification dated 10th January 1956.
this same institution was notified.
It is the institution was notified. Now it is repeated. There may be a grammatical mistake in my lord, this institution, my lord, your lordship will find at page number 19, coming under Srirangapatna Taluk, which commences on internal page 9, that is ink page 18, Srirangapatna Taluk, item number 29, Kiranguru Ramadevaru.
Kirangnur.
ಕಿರಂಗೂರು ರಾಮದೇವ್ ಅಂತ ಅಲ್ಲಿ ಕಿರನೂರು ಅಂತ ಬಿದ್ದಿದೆ RA ಇಲ್ಲ subsequently corrigendum is also issued. So to re-notify, opportunity need not be given. They had not challenged this 1956 notification. So even before 1956 it has been a Mujrai institution, and informally in 1956 this institution is notified as a Mujrai institution. What grievance they can have?
It's earlier notified.
My lord, now what has happened is, my lord, this and a notification that they state, my lord, it says that certain cash grants, my lord, were made available to certain institutions. This is what, my lord, it says. Please see, my lord, page number 10. It says that certain cash grants, my lord, was made. Now, two subsequent events, my lord, have taken place after this, which the state, my lord, would not urge. One is, my lord, along with my rejoinder, I have filed, my lord, the order of the land tribunal, where, my lord, I make an application in form number 7 concerning the very same property, my lord, which houses the temple. My lord, occupancy rate is registered in my name, and my lord, form number 10 is issued in my favor. My lord, along with my rejoinder, my lord, I have filed. The rejoinder is filed on 1/10/2024.
Now you represent whom?
Pardon, my lord?
You represent?
My lord, I represent the petitioner in the first petition.
Who is the petitioner?
My lord, the petitioners, my lord, are all children of one Ire Gowda. My lord, who was the person, my lord, who was taking care of the temple? My lord, he files application in form number 7 successfully, and my lord gets the registration of occupancy rate in his favor.
But once it's notified, was it available?
My lord, there is another judicial order that is passed. My lord, an inamti, my lord, claim is made. There, my lord, the tribunal comes to the conclusion that this is not an inam land. So two orders which says one confers right on me, and second it says, my lord, there is no inamti at all. Now there is only this notification which says certain cash grant was being made. It doesn't state, my lord, that this was ever under the control of the state. Now these two orders, my lord, will have to be considered, and there is absolutely no reference to it. The least, my lord, is the principle of natural justice, my lord, have been read by this honorable court, and my lord, the confirmed by the division bench, where it says, my lord, even when the declaration is to be given, I must be heard. Now these two orders will have to be considered by the authorities, and throughout thereafter, my lord, nothing happens. Now we, my lord, on a day-to-day basis take care of the temple.
The power to notify is under what section?
My lord, it is under section 23. Notified institutions is what, my lord, the heading would read.
Religious and charitable.
Please, my lord. Religious Institutions and Charitable Endowment Act 1997. That got done.
Under 23,
23, my lord.
now this notification, second notification is passed on what date?
Which one, my lord? The one that is impugned, my lord.
Yes.
My lord, this is passed on 29 September 2012. And it says, my lord, it is notified for the purpose of the said section with retrospective effect from 1/5/2003.
Now what do you say? But now they're saying that there is a order of grant of tenancy and Form 10 is issued.
Can you take our statement of objection? We have produced all the relevant documents. Statement of objection,
Yes.
para 5. In para 5, we say that petitioner has not approached the honorable court with clean hands. Then from para 6, we give the details. The lands belonging to Ramadevuru are as follows. Lands, survey number 649, 53, survey number 1088, then survey number 112 measuring 38 guttas, which is the subject matter. As stated earlier, 112 is a Dana land which has been given to the person cultivating it. Since it was originally a part of the property owned by the god, Sri Ramadevuru, the state decided to give annually as compensation to the temple by document dated 8/8/98. The said document is herewith produced as Annexure R2. Annexure R2, kindly see, this is the temple has received, that is what the act also says, to say that Tasdeeq, that is called as Tasdeeq amount, that is at page 34 of the statement of objection. Typed copy I am reading. Agkadali Tasdeeq amount is received.
No, but have you filed a rejoinder to
I
this?
have filed the rejoinder, my lord. I'll explain
Then-
this. What happened?
Just
is,
wait,
please.
wait.
Then, my lords, further on requesting for the kata of 3 portions of lands, namely survey number 649, 653 and 1088 to be made out in his name. This was rejected by the Land Revenue Tribunal, Pandupura, by its order dated 10/2/1982, citing the reason that as per the village accountant's record, the said land were not enam lands. The said order dated 10/2/1982 is herewith produced as Annexure R3, that is at page 35. The petitioner's father said Iregowda did not file an appeal against this order and hence the order has attained finality. Then, in the meantime, the petitioner approached the Assistant Commissioner Pandopura in proceedings bearing number 29/9697 dated 6/5/1997 seeking for kata in assessment number 25/A to be transferred to him. One Sri Basavanna had obtained kata in his name for the house in which the petitioner is presently residing, which is within the temple premises, that is Archakas. Challenging the same, the petitioner had filed a proceeding seeking for cancellation of the same before the Assistant Commissioner Pandopura. The Grama Panchayat of Kirangur was also made a party to these proceedings. AC, after considering the contentions of the petitioner, Sri Basavanna and Sri Grama Panchayat Kirangur, he was pleased to pass an order noting that neither the petitioner herein nor the respondent herein had any rights to the property as kata in respect of the said property is vested in the name of Sri Ramadevuru Devasthana and the same ought to be continued. The said order is produced as Annexure R4 at page 36, that is. Interestingly, the second limb of litigation arises when the petitioner files OS number 377 of 2014 seeking for a permanent injunction against a third party, Shivashekara, not to disturb the petitioner's peaceful enjoyment of property. The Honorable Court was pleased to dismiss the suit by judgment dated 6/8/2016, challenging the same. Petitioner filed regular appeal RA number 32/16 before the principal civil judge, JMFC Srirangapatna, wherein the judgment in OS number 377, 2014 was set aside and the appeal was allowed with cause as per Annex F to the writ petition. In all these proceedings, state was not made a party. Then meanwhile, the petitioner files an application dated 12/12/2016 to the Tahsildar requesting for Khata of the property to be made out in his name. By an inadvertent mistake, the Tahsildar makes a recommendation for making out a Khata in the name of the petitioner by filling out Form 10 and depositing rupees 9,224. However, the same was rejected by the Assistant Commissioner Srirangapatna by order dated 19/6/2017, produced as Annexure R5, which is at page 38, stating that the application before the Land Revenue Tribunal was rejected by order dated 10/2/1982 in 82 itself. Pursuant to this, the Tahsildar issued a notification dated 16/10/2017, withdrawing an order dated 12/12/2016, which was issued by him. The notification dated 16/10/2017 is produced as Annexure R6, which is at page 39. The petitioner filed another application in the office of the Tahsildar Srirangapatna, seeking for the Khata to be made in his name for the said lands. However, it was rejected on 7/9/2018 by the Tahsildar, stating that the only authority to hear the case on 1982 order is the Land Revenue Tribunal. Neither the AC Court nor the Tahsildar have the authority to look into the matter. Hence, rejected the application by endorsement dated 7/9/2018, Annexure R7, that is at page 41. Thereafter, the petitioner has filed, now the pending, has filed another suit in OS number 287 of 2021 before the Civil Judge Junior Division at Srirangapatna, seeking an order of injunction against defendants, that is Tahsildar, Deputy Tahsildar, Revenue Inspector, Srirangapatna. The plaint therein is produced here with us Annexure R8. Then it was on, now the next date is on 27/6/2025 for evidence. Further, the state notified the said temple by notification dated 30/4/2003. However, there was a typographical error in the said notification where the word Kiranguru was misspelled as Kinguru. Thereafter, another notification was issued by the state notifying the temple again in 2012 with the same error. That is the one which is challenged. At present, the Devasthana, Sri Rama Devasthana, situated in Shettihalli Hobli, Kirangur Grama, has been notified to be under the department by the impugned notification dated 29/9/2012. However, the typographical error had crept into this notification as well. Finally, the said error in the impugned notification was rectified by notification dated 26/7/2023 by the recommendation of Commissioner Endowments on 21/1/2023. The said recommendation dated 21/1/2023 and amended notification are herewith produced as annexures 9 and 10, which are at page 48, Tiddupadi Adesha. That they don't dispute. Page 48 ನಲ್ಲಿ annexure R10 ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 2012 ದಿನಾಂಕ 29/9/2012 ಅಧಿಸೂಚಿತ ದೇವಾಲಯಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ನೋಟಿಫೈಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಪುಟ ಸಂಖ್ಯೆ 575 ಕ್ರಮ ಸಂಖ್ಯೆ 69 ಪ್ರಕಟಿಸಿರುವ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕು ಕಿಂಗೂರು ಗ್ರಾಮ ಶ್ರೀ ರಾಮದೇವರು ಎಂದಿರುವುದನ್ನು ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕು ಕಿರಂಗೂರು ಗ್ರಾಮ ಶ್ರೀ ರಾಮದೇವರು ಎಂದು ಓದಿಕೊಳ್ಳತಕ್ಕದ್ದು. This is at 48. The petitioner, then my lords, para 16, page 7. The petitioner or his family members have no right over the temple or the surrounding lands of the temple whatsoever. In fact, the state has passed an order appointing one Sri Ramaswamy as the Archaka to carry out the activities of the temple. They are preventing him. The petitioner misleadingly relies on a communication dated 6/12/1987 by the Commissioner Religious and Charitable Institution, which states that the mere fixing of annuity will not mean that the temple belongs to the state. Further, the RTC for the said lands till date are in the name of the god Ramadevaru. RTC for the above mentioned 3 lands are herewith produced as annexures are 11, 12 and 13. The bank statement disclosing payment of regular annuity to the temple is herewith produced as annexure R14. But this is at page 52.
No, but now once as per annexure R3,
Please.
R3 is filed by whom? You are a party.
Please, my lord, annexure R3, I am party. Please
so-
see that, my lord, the reason for rejection is this. This comes under the Inam Abolition Act. The claim is made under the Inam Abolition Act. Two claims are made by me. One under the, my lord, form number 7 before the Land Tribunal. Second is, my lord, the Inam Abolition Act. The finding that is recorded here is, my lord, please see in the operative portion. One para before the operative portion. ಅರ್ಜಿದಾರರುಗಳ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಅರ್ಜಿದಾರರುಗಳ ಹೇಳಿಕೆ ಮತ್ತು ಗ್ರಾಮ ಲೆಕ್ಕ ದಾಖಲೆಗಳಿಂದ ಮೇಲ್ಕಂಡ ದಾವಾ ಜಮೀನುಗಳು ಇನಾಮ್ತಿ ಜಮೀನು ಅಲ್ಲವೆಂದು ಕಂಡು ಬಂದಿದ್ದು ಇನಾಮ್ತಿ ರದ್ದಿಯಾತಿ ಕಾಯ್ದೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲವಾಗಿ ಸ್ಪಷ್ಟವಾಗುತ್ತದೆ. ಮೇಲೆ ತಿಳಿಸಿರುವ ಕಾರಣದಿಂದ ದಾವಾ ಜಮೀನುಗಳು ಇನಾಮ್ತಿ ಜಮೀನುಗಳಲ್ಲವೆಂದು ದೃಢಪಟ್ಟಿರುವುದರಿಂದ ಅರ್ಜಿದಾರರುಗಳು ಅರ್ಜಿಗಳನ್ನು ವಜಾ ಮಾಡಬಹುದೆಂದು ಈ ಭೂ ನ್ಯಾಯಾಧಿಕರಣವು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಿ ಆದೇಶ ನೀಡುತ್ತದೆ. So the finding that was recorded, my lord, that this is not an Inam land. The moment, my lord, it is not an Inam land. So the state, my lord, cannot claim. What the state says is, by the virtue of it, the Inam being abolished, I was paying the stake, and hence, my lord, it comes under section 23. But please see the survey number to which, my lord, annexure R2 would refer to, page number 31. Now that is concerning a different survey number in survey number 112. The present one, my lord, is in survey number 1088, for which, my lord, this present order is concerned. Annexure R3 doesn't concern survey number 112. It concerns 1088.
So you claim your right under which,
My
which
lord,
proceeding?
along with my rejoinder, my lord, I have produced the order of the Land Tribunal as well as, my lord, the form number 10 that has been issued to me. My lord, rejoinder has been filed on 1/10/2024. My lord, page number 11, my lord, is the typed copy of the said order. 34/1979, my lord, in LRT number 13 of 1978-79. My lord, order comes to be passed. My application in form number 7 is page number 6 of the rejoinder, where, my lord, 1088 figures out.
But it is the stand of the state that it never belonged to any private person.
My lord, state has
Now you have set up somebody as a landlord and obtained your rights.
My lord, state has suffered the order. Annexure R3, state is a party. My lord, the state is heard, and, my lord, a finding is recorded that it's not an Inam land. Now state cannot, my lord, wriggle out of the order that they themselves have produced. If it is not an Inam land, my lord, my claim, my lord, would be against the rival claimant and the landlord. My lord, that is permitted. Now, of their own say, my lord, annexure R3, page number 35, my lord says, Ramdevru, my lord, is represented by the Tahsildar Srirangpatna.
Correct. So where is, then the ownership is with the state.
My lord, no, the ownership is, no, my lord, if it was an Inam land, my lord, by the virtue of the Inam.
Merely because it is not Inam land doesn't mean the state is not the owner of it.
My lord, now the ownership, my lord, ultimately will have to vest in the state. It has to vest, my lord, by the virtue of either the Land Reforms Act or the Inam Abolition Act. Now the finding is that it's not an Inam land.
No, that is not necessarily so.
Well, the reason is the vesting will have to happen, my lord.
That
The
is
vesting
only
with the state.
in case of land falling with the properties falling within the purview of the act. All state properties need not necessarily.
Well, there is no evidence or material to show that at any point of time there was a state control,
That
except that annexure R1, my lord, which says only cash grant was made, my lord, in the year 1956. Thereafter, my lord, not even a single piece of document is there. My lord, throughout for 75 years, my lord, we have managed it under the orders of the tribunal and also, my lord, by the orders of the Inam DC.
No, but the records indicate otherwise.
My lord, no, the records also, my lord, I'll take, my lord, to annexure R2. Please see, this is how, my lord, they are saying that I have paid.
Now we'll
this
see.
estate.
Now there's only one point that you'll have to clarify, that the property belongs to the state. That we
Now, kindly take section 23 of the Act. But what 23 says is, state government shall, as soon as may be after the commencement of this Act, that Act has come into force on 1/5/2003. Act published by notification in respect of each revenue district a list of all charitable institutions and Hindu religious institutions which on the date of commencement of this Act are in the sole charge of the state government under the provisions of Mysore Religious and Charitable Institutions Act 1927. So we have produced a document under 1927 Act, a notification in the year 1952-56 are published. So this is one of the institutions which is found in the list. Then, or for the benefit of which any monthly or annual grant in perpetuity is made from public revenue, or tasdeeq allowance under section 19 of Mysore Religious and Charitable Inams Abolition Act 1955 piece. Tasdeeq has been paid, that we have produced all the annexes. Then come to EE. All Hindu religious institutions which are in receipt of any monthly or annual grant from public revenue or any amount under the Karnataka Certain Norms Act 1977. So these are all included in the notification. There is no dispute that this temple has been receiving tasdeeq for last several decades. Then this is one of the institutions notified under the 1927 Act as per Annexure R1. So where is the dispute? They have not challenged it. If they were to be in possession and enjoyment of the lands attached to the temple and the temple itself, then they would have challenged it earlier.
What is the effect of it being notified under 23?
The moment, my lord, it is notified, then it becomes a Mujrai institution, a state government property. All that we have done is, we have notified under the Act, because new Act has come into force with effect from 1/5/2003. So there was some error in mentioning the name, that also has been rectified as per Annexure Act. Anyway, they have petitioner has filed a civil suit that is pending.
Suit against
Suit against the Tahsildar and the revenue inspector.
state?
What against the state? That is at, I have produced a copy of the plaint also. Plaint copy is at Annexure R8 at page 42. Page 42, Annexure R8, OS number 287/2021. Plaintiff is Mahadev, the red petitioner. Defendant is Tahsildar, revenue inspector. I don't know what declaration he will seek against revenue inspector, who can't be opponent. Then the relief sought for is at page 44. Plaintiff most humbly prays, Honorable Court may kindly be pleased to judgment and decree in his favor against the defendants for permanent injunction restraining the defendants or anybody or their behalf from interfering with peaceful possession. Only for permanent injunction, not even a declaration that he is the owner. Anyway, it is.
No, but now you cannot challenge the notification. On what ground you challenge?
The reason is this, my lord, I'll say this why I'm challenging. My lord, what is required of section 23 is, my lord, the sole control of the state, which, my lord, not even a single document is
So
shown.
it says if tasdeeq is being
My
thin,
lord, Tasdeeq, I'll, my lord, point out to Annexure R2. Please see Annexure R2 what they have produced. It doesn't concern my land at all. Please see Annexure R2 page number 31 along with the statement of objection. Now my land is in 1088, for which, my lord, the orders are passed. Now they state, my lord, it is concerning survey number 112. This is in the year 1968, I believe, or 1988. My lord, it's not clear. Please come to page number 31.
let us see, it requires some detailed hearing. I'll fix a date next week.
Yes, ma'am.
You prepare a synopsis.
Please, I'll prepare a synopsis.
But now if it belongs to the state or the state has control and they notify it, the order in the land tribunal by arraying somebody else as a landlord may itself not be
Sir,
sufficient.
not only the land tribunal order, my respectful submission is, when, my lord, claim was made under the Inam Abolition Act, they did not say that this is a notified institution.
It is not their
They
claim.
suffered an order.
It's not their claim. It's only the finding is it's not an inam.
Yes, my lord, then the state must say, till then, my lord, till I filed this petition, in none of the communication, my lord, that they ever stated that it was under the state control or that it was notified. My lord, only after I got to know, my lord, I filed the writ petition.
No, but 1959 notification.
Sir,
what
that's,
is-
my lord, a cash grant for that year. What happens is,
That is a ground under 1920, under the Act,
sir,
under section
in the
20.
1927, my lord, they must notify it as an institution. Even then, my lord, for a year, now what has to happen under section 23 is, my lord, either perpetually, my lord, or monthly, my lord, there must be an annuity. Now what they produce is 2018, my lord, they now produce the state bank statement. Till then, nothing happens.
1959.
Well, that year, my lord, they produce. Thereafter, the next document they produce is of the year 2018. They never, my lord, ever, my lord, claimed any claim or the state control over this property.
No, but
And it must be a perpetuity.
let us see.
My lord, I'll point out, my lord, as to how it doesn't come.
Relist week after next date code. 18th.
Please.
You prepare a synopsis.
Yes, I'll do that. Lord, interim order.
Interim order in operation is extended till the next date.
Both
Right.
matters. Connected matter also interim order is there, that also.
Respondent number 3,
Yes.
the issue of
Appearing for the petitioner, my
maintainability of,
lordship, this is my case, I may be allowed to make a submission.
issue of maintainability is a question, my lords.
My lordship, kindly, I am representing Divya Construction, the petitioner before this honorable court. My lordship, I request this honorable court to pursue page number 61, annexure G.
Before going to
lordship,
merits, my lords,
I may be allowed
maintainability is a
to make a
question
submission.
because it's a waste before
My lordship, I may be allowed to read the
Now
order.
the proceedings under the
RERA,
IBC, huh?
RERA, my lords.
It is the proceedings under IBC, my lordship. I may be given 2 minutes time to give a clarification.
What have you challenged?
My lordship, I have challenged the notice which I have produced in the IA number 4, page number 11.
So what is the main writ petition filed against?
Yes, my lordship, I may be allowed so that I will explain. My lordship, in the page number 61, annexure G, there is a RERA order. My lordship, RERA order, see, this
Page?
page number 61 of the petition, my lordship. Serial number 40 and 41 is connected matters. Both the parties are the husband and wife, my lordship. They have invested in a project called Divya JSR Limelight, developed by Divya Infra Properties Private Limited. Since they have not got the possession of the property, they have approached RERA, and RERA have passed the orders. The order has been produced as annexure G, page number 61. My lordship, parties are clearly, we can see that this is against Badrinath Divya JSR Limelight, Divya Infra Properties Private Limited. ತೀರ್ಪು ಈ ಫಿರ್ಯಾದಿಯನ್ನು ಪ್ರದೀಪ್ ಕುಮಾರ್ ಬಿ ಎನ್ನುವರು
Just 1 minute. What is the main prayer in your writ petition?
My lordship, I have asked for quashing the recovery proceedings because I am a Divya Construction who is a partnership firm.
Recovery proceedings initiated by whom?
By RERA.
By?
RERA has passed orders against Divya Infra Properties Private Limited. Accordingly, in the page number 60, 70 and 75, RERA has issued an order to the special Tahsildar saying that so-and-so order has been passed against the respondent, Divya Infra Properties Private Limited.
Just a minute. Now against proceedings under RERA,
Yes, my lordship.
is there no appeal?
My lordship, there is no appeal. I am not Divya Infra Properties Private Limited. That may be noted, my lordship.
No, that we'll see. I'm saying where is the annexure A is only the order of attachment.
Yes,
Where
my
is the
lordship.
order of RERA?
Page number 61, my lordship. Page number 61, ತೀರ್ಪು, my lordship.
This order is, do you have a typed copy? It's not legible at all.
We have produced a typed copy, 65 and 69, my lordship. Page number 65 to 69.
Now the proceedings are initiated by you,
Yes, my lords.
Pradeep Kumar.
Yes, my lordship.
So you have approached RERA for what relief?
My lords, I paid 30 lakhs. They have not completed the project. Neither they have not completed the project or not refunded my money. So I approached the RERA. Orders were passed.
What is the operative portion at annexure
Let's here.
page
they
68?
themselves-
64, my lordship. It's in,
68.
yes, my lordship.
Annexure G, my lords.
Ah,
Page 61.
60,
61.
typed copy at 65.
69, my lordship.
65 is typed copy.
The operative portion is in 69.
My lords, before going to the merits,
My lordship, I
Just
before.
wait.
my lords
Just wait.
here, maintainability, they have to approach the appellate tribunal. If there
The
is any
section?
RERA order
Under section
under section 43 clause 5
of
RERA Act. Even the Supreme Court
Lordship, that is
also.
not my
just
case, my
wait,
lordship.
just wait,
Submit.
just wait. Yes,
Even
go
the
to
Supreme
Rera.
Court
Rera.
categorically held any person. I'll read my lords.
43.5.
Clause 5. Establishment of real estate appellate tribunal. Any person, it is said, any person aggrieved by any direction or
No.
decision
Is there
or
a-
order made by the authority or by an adjudication officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter. Provision provided that where a promoter files an appeal with the appellate tribunal, it shall not be entertained without the promoter first having deposited with the appellate tribunal at least 30% of the penalty or such higher percentage.
I apologize.
may
to-
be,
My lordship,
and,
this is not my
determined by-
case.
Just
I'm
wait.
not challenging that
Just
order at
wait.
all,
That's
my lordship.
here,
Just wait. Now under 43.5,
43 fly.
there is an appellate authority
Yes, my
that
lords.
is established.
Established. 2019, I have a notification also.
So you're saying any person aggrieved will include even third parties
Any
if there
person.
is.
Yes, my lords.
Now what is the operative portion of the order at pay, order? That he has to pay 28 lakhs 35,000.
Page 64.
They have to return the money.
Yes,
Yes, sir. Along with interest.
Now this order is passed against Badrinath,
yes, my lords.
Divya JSR Limelight.
Yes, my lords.
Now you have sought to execute this order
Yes, my lords.
in separate proceedings.
No, what happened here, my lords? Divya Infra Property Limited, there are 3 directors in it.
No.
One is MS Ravi Prasad,
Cover on the-
Veni, Ravi Prasad, Veni, and they have a firm, construction firm, partnership firm, where they themselves,
My lordship, it's a wrong submission.
Just wait, I'll come
Wait-
to you. Just wait.
Yes, my lordship.
I'm trying to understand.
let's hear,
Yes.
these partners, they've made a firm. That is a construction firm. They themselves in the writ petition have said, we are a construction company and we build properties. And I wrote a complete,
Now, how do you enforce this order? What is the procedure under the act?
let's hear.
Yes.
Enforcement is, with the
Enforceability
state.
through the Tahsildar,
Hmm.
the deputy commissioner. The RERA issues a recovery certificate after an order has been passed. Based on the recovery certificate, the deputy commissioner delegates the power to the Tahsildar to attach the properties and auction and repay the money to the
Right. Now, where is the recovery certificate?
recovery certificate is here at
Last page, my lords.
last page, my lord, 67, 67 and
Page?
60. 67 and
Annexure
68.
J 67, my lords.
67, 68, 69. ಒಟ್ಟು ಬಾಕಿ ಯೋಜನಾ ಮೊತ್ತ ರೂಪಾಯಿ 44,31,87ಗಳನ್ನು ವಸೂಲಿ ಮಾಡಬೇಕು.
Annexure,
This is the order.
annexure,
Annexure.
Annexure A, page number 16, my lordship.
J, my lord, J, annexure J,
annexure.
annexure J. Annexure J, my lord. It starts at page 67, ends with 69.
My
No, the
friend is
page numbers,
reading
they have given
8627
different.
petition.
Annexure J.
No, 8626.
My lordship,
27.
I may be given just one.
I'll
minute
come
for
back to you. I'm
clarification.
trying to understand. Annexure J.
ಹೌದು.
Page numbers you must give correctly, madam. Which is the page number? Annexure J.
75, my lordship.
75. It's not legible at all. Page typed copy.
typed copy of annexure J in page number 78, my lordship.
78.
Yes, my lordship.
Now this is the recovery certificate.
Yes,
Now this one,
based on the recovery certificate, by virtue of an arrears of land revenue, we initiate action to attach the properties of the developer, auction it in public auction, and if at all, whatever the amount is received has to be given to the petitioner.
now you have challenged this annexure J.
Yes, my lordship. Annexure J, I'm not challenging annexure J as well, my lordship.
Yeah.
I'm not at all challenging any of the orders and recovery certificate issued by RERA authority. My lordship, even which they are saying that as per annexure J, they have issued a recovery certificate. My lordship, that is against Divya Infra Properties Private Limited. I may allowed to read this. RERA ಕಾಯ್ದೆ ಕಲಂ 40 subclause 1 ನಿಯಮ 25 ಅಡಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಕ್ಲೇಮ್ ಅರ್ಜಿಯನ್ನು ಯೋಜನಾ ಪಾವತಿಯನ್ನು RERA ಕಾಯ್ದೆ ಪ್ರಕಾರ ನ್ಯಾಯ ನಿರ್ಣಯಿಸಿ ಪ್ರತಿವಾದಿಗಳು ಅರ್ಜಿದಾರರಿಗೆ ಬಾಕಿ ಯೋಜನೆ ಮೊತ್ತ ಸೋ ಅಂಡ್ ಸೋ ಗಳನ್ನು ಪ್ರಾಜೆಕ್ಟ್ಗೆ ಕೊಟ್ಟಿದ್ದ ಹಣ ಮೊತ್ತವನ್ನು ನೀಡಬೇಕೆಂದು ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ತೀರ್ಪನ್ನು ಆಶ್ವಾಸನೆ ಮಾಡಿರುತ್ತಾರೆ. ದಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿವ್ಯಾ ಇನ್ಫ್ರಾ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್, ದಿವ್ಯಾ JSR ಲೈಮ್ಲೈಟ್. ಮಿಲಾರ್ಡ್ಶಿಪ್, ಇಲ್ಲಿ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ ಪ್ರಕಾರ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಾರೆ. ವಿ ಆರ್ ನಾಟ್ ಕ್ಲೇಮಿಂಗ್ ದಟ್ ಬಿಕಾಸ್ the project is been developed.
So what are you challenging now?
I am challenging the page number 11 of IA number 4, my lordship. Kindly that may be looked into.
Order of attachment.
Order of?
Attachment with it. Special Tahsildar.
Page number 11 of IA number 4.
With it, special Tahsildar has been challenged.
IA number has been filed post the petition has been filed, my lordship. There would be a different document for that. Sir, IA number 4, please. IA number 4 kodi. Ide. Okay. My lordship, IA number 4 ಅಲ್ಲಿ page number 11. This notice was issued on 10th of May 2025 to the petitioners. My lordship, I may be allowed to read that.
Copy has not been served.
That has been already served on the last date of hearing. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
We don't know what
ಪ್ರತಿವಾದಿಗಳಾದ
Just 1 minute, madam. Please wait.
Yes,
I have not found your IA number 4. Manjunath. Iದೇನು IA number 4 ಅಂತ ಏನು ನೋಡಪ್ಪ. ಅದ್ಯಾವ IA? ಅವ್ರ ಹತ್ರ ಇದೆ.
not seen the, even the state also has not got the.
No, I have received a copy of the.
No, this petition is there, but there is a
Here for
present
quashing.
Japti.
page number 11, my lordship.
Present Japti.
IA number?
IA number 4, page number 11.
Quashing ಅಂತಿದೆ.
IA 4 of 25.
Yes, my lordship.
Now page?
Page number 11, my lordship.
Attachment of what?
Yeah, Japti Hukum.
Yes.
Japti Hukum. It is a Japti Hukum, my lordship.
Yes.
I'll just read first four lines of this. ಜಪ್ತಿ ಹುಕುಂ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಗಳಾದ ಬದ್ರಿನಾಥ್ ದಿವ್ಯಾ JSR ಲೈಮ್ಲೈಟ್, ದಿವ್ಯಾ ಇನ್ಫ್ರಾ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್, ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಬೆಂಗಳೂರು, ಪೈಪ್ ರೋಡ್ ಬೆಂಗಳೂರು ಸೋ ಅಂಡ್ ಸೋ ರವರಿಂದ ಅರ್ಜಿದಾರರಾದ ಪ್ರದೀಪ್ ಕುಮಾರ್ ಅಂಡ್ IR ರಶ್ಮಿ. ಮಲೋಶಿಪ್, IR ರಶ್ಮಿ is in the serial number 40 subclause 40/1 ರವರಿಗೆ ಕರ್ನಾಟಕ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅಧಿಕರಣ ಆದೇಶದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಸೋ ಅಂಡ್ ಸೋ ಅಮೌಂಟ್ ಅನ್ನು ಪಾವತಿಸಬೇಕೆಂದು ಆದೇಶಿಸಲಿರುತ್ತದೆ. ಮಿಲಾರ್ಡ್ಶಿಪ್, ಇನ್ ದ ಟ್ಯಾಬ್ಯುಲರ್ ಕಾಲಮ್, ದ ಫಸ್ಟ್ ಟ್ಯಾಬ್ಯುಲರ್ ಕಾಲಮ್, ಫಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್, ನಗರ ಪಟ್ಟಣ ಗ್ರಾಮದಸರು ಸುತ್ತದಾರರ ಮೀನ್ಸ್ ಡಿಫಾಲ್ಟರ್ ಈಸ್ ಬದ್ರಿನಾಥ್ ದಿವ್ಯಾ JSR ಲೈಮ್ಲೈಟ್, ದಿವ್ಯಾ ಇನ್ಫ್ರಾ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಅಂತ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಅದ್ರ ಕೆಳಗಡೆಗೆ ಅಟ್ಯಾಚ್ ಮಾಡೋ ಪ್ರಾಪರ್ಟಿ ವಿವರನ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನ್ ಹೇಳ್ತಾರೆ? ಬದ್ರಿನಾಥ್ ದಿವ್ಯಾ JSR ಲೈಮ್ಲೈಟ್ ಫ್ಲಾಟ್ಸ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇನ್ ದಿವ್ಯಾ ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್. ದಿಸ್ ಇಸ್ ವಾಟ್ ಐ ಆಮ್ ಚಾಲೆಂಜಿಂಗ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್. ಇದರಲ್ಲಿ ಎರಡು ಪ್ರಾಜೆಕ್ಟ್, ದಿವ್ಯಾ JSR ಲೈಮ್ಲೈಟ್ ಇಸ್ ಅ ಡಿಫರೆಂಟ್ ಪ್ರಾಜೆಕ್ಟ್ ವಿಚ್ ಇಸ್ ಡೆವಲಪ್ಡ್ ಬೈ ದಿವ್ಯಾ ಇನ್ಫ್ರಾ ಪ್ರಾಪರ್ಟೀಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್, and they're also including Divya Landmark, which is developed by Divya Construction. This is what I'm challenging, my lordship.
Who are you now?
I'm Divya Construction, a partnership firm. I have produced the partnership deed.
Now you are not related to Divya Infra.
No, my lordship. That is what my objection is. Come. And my lordship, I have on the last occasion I have produced the NCLT order, my lordship. Kindly that document may be perceived, sir. NCLT order last time.
You have nothing to do with Divya Infra project.
Yes, my lordship, that is what my point is, my lordship.
Divya Infra Properties, you're not a director nor related to them.
No, my lordship, that's what, the company is under insolvency proceedings.
Which company?
Divya Infra Properties Private Limited. I may be allowed to read sections 14 of IBC code.
But who are you now?
My lordship, I am Divya Constructions, a partnership firm. The partnership deed has been produced as Annexure B.
Who are the directors of Divya Infra?
Aslam Pasha, Ravi Prasad and Veni and Andal Devi. There are 4 partners in this firm, my lordship.
Have you made them as parties?
They are not a parties before RERA, my lordship. I am representing as
Madam,
Divya Constructions,
the order is passed against,
Divya Infra Properties Private Limited.
yes, have you made them parties to the present petition?
No, my lordship,
Why not?
because I'm not challenging
That's a different matter. You can't now get away without making them as parties.
I will not be able to make them as a party, my lordship, because there is a insolvency proceedings is going on.
That's a different matter. You make them parties, let them come. We'll see what is to be
My
done.
lordship, I may be allowed to just read section 14 of IBC Act.
We are aware of that, but I want to.
ಅದರಲ್ಲಿ ಅವ್ರು ಯಾವುದೇ ರೀತಿ ಹೊಸ ಕೇಸ್ನ ಇನ್ವಾಲ್ವ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
Why are you taking their case?
I am not taking their case, my
I'm
lordship.
asking you, the order is passed against Divya Infra Properties.
Yes, my lordship.
Now you have nothing to do with them.
My lordship, I'm
Their
yes.
government is trying to execute against them.
No, against me. My lordship, Divya
don't-
Landmark, I may
the-
be allowed to give this documents.
No, why are you shying away from impleading them?
No, I may be allowed.
You implead, we'll hear the matter.
My lordship, now my only submission is, let them do whatever they want to do against Divya Infra Properties. They also have made a claim before the RP, which claim has already been accepted. I have produced the document before this honorable court. That is also been covered by the Supreme Court judgment. When such recovery insolvency proceedings is going on, no such new proceedings or any execution cannot be allowed against the corporate debtor. I am not at all representing any of that. My lordship, I am producing the ownership of the flats which they have attached. My lordship, only 2 points I'm going to tell before this honorable court is, the properties they have attached is they illegally they have added a name as Divya Landmark. I am trying to convey to before this honorable court is, the ownership of the so and so property is by Divya Constructions. EC I am been producing. I mean Katas, e-Katas.
So Divya Construction has nothing to do with Divya Infra, or is it related?
Nothing to do with Divya Infra Properties, my lordship. This is a Divya Construction. My lordship, this property.
Just 1 minute. Divya Infra, the directors or partners of Divya Infra and Divya Constructions are different.
Yes.
There are different parties in the Divya Constructions and there are different parties in the directions.
None of
companies.
Now Divya Construction is a partnership firm.
Divya Construction partnership firm.
None of the partners are partners of this.
Two parties of Divya Construction is the director of Divya Infra Properties Private Limited, my lordship. Here, my submission is, see, when there is a similar party between two distinct entity, there should be a corporate wheel being pierced. When there is a substantial evidence, there is some kind of a amount is being mismanaged or been diverted to different company, then they can hold any other person as a liable. But before this honorable court, the question is, this property was concluded in 2010, my lordship. Has a Divya Construction,
Now,
they have
which two directors, now is Divya Construction a partnership firm?
Yes, my lordship.
And Divya Infra?
The limited company.
That is a limited company, private limited company.
The MD of.
And my lordship.
Just 1 minute, but you will have to enforce it against the company.
Yes.
Then how can you go against, just wait. How can you go against somebody other than the company? Insofar as enforcement of an order against Divya Infra Properties, if it's a company, you will have to go against the company and its assets.
Yes, madam.
You can't go against anybody other than the company.
Yes, madam.
And they are saying IBC proceedings against which?
Divya Infra Properties Private Limited.
IBC proceedings.
Yes, my lordship. Company.
Okay, let us see. Then you may have to take other steps for enforcement.
Yes, sir.
They say, no, present proceedings will keep it in abeyance.
Yes, sir.
Reserving liberty for you to take other proceedings to enforce.
Yes.
Regarding this, we'll see.
Yes.
My lordship, one more submission. ಇವ್ರೇನ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಿದಾರ ಸ್ವಾಮಿ ಇಷ್ಟಿಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ
No, that's-
as per IBC proceedings they already have submitted the claim before RP.
No, that
ಅದನ್ನ
will-
ಅವ್ರು accept ಸಹ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. I have produced before this honorable
No,
court.
that we'll see.
May I submit, my
Yes, my lordship. Page number.
No, that we'll see later. That we'll see.
May I
My
submit?
lordship, I am
Take a step.
seeking a protection
My
that
lords,
these property cannot be under the recovery proceedings, my lordship.
My lords,
Because I have clearly given the ownership, which is nothing to do with Divya Infra Properties Private Limited.
Now, the attachment order is as against the property.
Against
flat
individual
number.
flats.
My lordship, one more idralli one.
No, just 1 minute. Let me understand. 307, 309, 402, 403, 404. Now that stands in whose name?
That is in the Divya Construction, my lordship. E-Khata has been produced.
No, no, properties ought to be attached is these flats,
Yes, they have attached these plans.
these flats.
My lordship, kindly one more.
Properties ought to be attached
Oh,
by the attachment notice of 6425.
Yes, sir.
Is which are the properties that ought to be attached?
the.
Divya Construction.
6425,
Uh,
your attachment notice which you have produced at page 11.
Yes,
Page 11 of your IA.
yes, my lordship.
What is the attachment is of which property?
My lordship, ಅವರು 307, 309, 402, 403, 404 ಅಂತ ಏನ್ ಹೇಳ್ತಿದಾರಲ್ಲ ಸ್ವಾಮಿ.
Now this property stands in whose name?
Divya Constructions.
That's a different entity,
Yes, my lordship.
not Divya Infra.
Yes, my lordship. And the ownership,
Just show me those property documents.
yes, just now I have produced a copy of page number 34, my lordship.
Page
34. Idralli, page number 34, my lordship. Flat number 309.
stands in whose name?
Divya Landmark, the next page, my lordship. 35, page number 35 ಅಲ್ಲಿ ಮಾಲೀಕರ ಹೆಸರು Divya Constructions.
Now you have to verify this. Verify this.
let's one submission. my lords.
And the next page
No,
for
we'll
the
see.
flat
So
number.
all these properties, the document show it's in Divya Construction.
Yes, my lordship.
My lords,
Yes.
after the decree was passed, I made a representation to Tahsildar stating that I'll make this.
Execution. Issue.
Copies, please.
I'll give.
So now. we'll
Let's ಇದ್ರಲ್ಲಿ
consider-
ಏನಾಗಿದೆ ಅಂದ್ರೆ
No, correct. But now let them proceed against Divya Infra. Present proceeding will have to stay.
my lords,
We'll see what is to be done.
section 200 of KLR Act may be seen.
Yeah.
Why? Because I made a representation. These directors
Or also.
the directors are part and parcel of the company. So kindly invoke under section 20
Can't do that.
200.
You can't do that. You can't do
Well, let's hear.
against a company where IBC proceedings
Well,
are
let's
also
hear.
pending.
Prior to decree,
if
it was
IBC
not, there was no IBC.
No, IBC proceedings were extinguished.
Now
all.
they have started
That
that.
you look into it. What is the legal effect? And if you, unless you are a part of the resolution plan, you will lose your rights.
Well, let's
Examine
hear.
that. Examine that independently.
Let's hear one more submission, my lords. Writ petition is not maintainable. Why? Because due to the fact that there is a Supreme Court
No, it's without-
judgment, New Tech Promoters, where it says, if any person who is aggrieved by the order of the ARERA Act or anything, kindly go before the appellate tribunal.
But that is
They
not
can't come
making
before
sense.
the High Court and say that,
You're right.
this violation or something else.
You're right, but there are exceptions.
Definitely, my lords. If the exceptions are,
Now here
if they are genuinely stranger to that,
Let us-
definitely acceptable.
Requires
They are
hearing.
part of the
requires
company
hearing, let us.
and they make this separate entity and then they
But
do
if-
it.
once there's a
My
com-
75 lakhs plus interest passed from
Correct.
several
No,
decades
you have
has
to-
been abeyance.
Correct. If you ignore the IBC proceedings, it's at your risk.
That's the IBC proceedings is invoked after this decree.
Maybe, but you have to be a part of the resolution plan.
Please.
Obtain protection. The,
My lordship, before
what
that
is,
one.
what is, just wait. Now, what is the interim relief you're seeking?
My lordship, I'm seeking the stay of recovery proceedings against Divya Constructions.
Annexure?
Annexure A in the main petition as well as the notice in the IA number 4 and IA number 2. They are again and again they are issuing the Japti Hukum notices.
The counsel for the petitioner submits that the petitioner is a registered partnership firm
Yes, my lordship.
and the claim by respondent number
3, my lords.
3,
3.
respondent number 3 is as per the order of RERA against Divya Infra Properties Private Limited. Full stop. Submitted as the said company is the respondent in the RERA proceedings. Execution of certificate of recovery cannot be enforced against the petitioner, which is a different legal entity. In light of stand taken that the proceedings against the petitioner are one without jurisdiction, there will be stay of proceedings in RERA 626/2018-19 as against the petitioner herein. Full stop. It is made clear that the private respondent is at liberty to seek for enforcement against Divya Infra Properties Private Limited as is permissible under law. Now you take your stand.
Well, that's only
my
notice
lordship.
can be stayed
Yeah.
because in an earlier order, there was a categorical direction. This petition will not come in a way and but
ಆ
order
ಟೈಮಲ್ಲಿ
passed
ಯಾರು
ಮಾಡಿಲ್ಲ.
ಪಿಟಿಷನರ್ ಕಡೆ ಬಂದೇ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ ಅವತ್ತು ರಿಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದಾಗ
some
ಅದು
allowed it,
ಏನು
There was a
ಗೊತ್ತಿರಲಿಲ್ಲ.
categorical
Just one
order
minute.
by earlier court
No, no,
stating
recovery,
that this
recovery,
was-
based on the recovery certificate, my lord, if at all, if it has to approach the insolvency professional before whom he has to file the claim
It's
petition,
it's open
that
to-
would survive, because that is not challenged in this petition.
Yes, yes.
All that is challenged in this petition is only the notice issued by the special
Against
tahsildar.
the petition.
Yes, the notice against the petitioner can be stated in this court. That's it.
And my lordship, one
He is free to approach the.
No, now we could rather dispose it of itself,
Yes,
yes, my
ma'am.
lordship, kindly.
Yes, dispose of.
keeping open all other contention.
Yes, ma'am.
And your rights against Divya Infra.
Yes.
I will not comment on the IBC proceedings, I'll keep it open.
Yes.
The present petition has been filed by Messrs. Divya Constructions. You have not mentioned the partners' names who represent the petitioner.
The partnership deed has been produced, my lordship.
It is the case of the petitioner
That itself is strategic.
that
Name of the partner.
the
managing partner must represent, but the another partner is coming before this court. Affidavit may be seen across.
As a Divya Construction, we have approached before this honorable court, my
Actually,
lordship.
so you have to mention, isn't it, in your cause title? The case of the petitioner is that it is a registered partnership firm. Copy of the deed is produced at annexure
B, my lordship.
Annexure B. And the attachment notice at annexure A has been issued by the special tahsildar seeking to execute order passed by the RERA court in case number 626 of 2018-19. Full stop. It is submitted that the said proceedings under the RERA Act are against the Divya Infra Properties Private Limited, which is a company.
Yes, my lordship, private limited company.
And an order passed against such entity cannot be enforced against the petitioner, which is a different legal entity. Further contended that even if some of the partners of the petitioner firm are directors of Divya Infra Properties Private Limited, the proceedings must be limited to the company and cannot be proceeded against the present partnership firm. Full stop. Notice the order at annexure J. An order is passed against Divya Infra Properties Private Limited. Full stop. The notice of attachment of properties by the Revenue Authority is against properties which petitioner asserts to be properties of the partnership petitioner partnership firm.
Yes.
Full stop. Said assertion is not controverted. Full stop. Needless to state, an order passed against Divya Infra Properties Private Limited, which is a company, cannot be enforced against a different legal entity, that is the petitioner firm. Accordingly, the notice at annexure A is set aside as it seeks to enforce the order of RERA against the petitioner herein. No, but annexure A is against Divya Infra, not against you.
ಮಿಲೋರ್ಶಿಪ್ ಅಲ್ಲಿ ಕೆಳಗಡೆಗೆ ಅವರು ದಿವ್ಯಾ ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಅಂತ ಏನ್ ಬರ್ದಿದಾರಲ್ವಾ ಅದು ದಿವ್ಯಾ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪ್ರಾಪರ್ಟಿ ಮಿಲೋರ್ಶಿಪ್. ಅವ್ರು ಇವನ್ ನೋಟಿಸ್ ಕೊಡುವಾಗ್ಲೂ ಅವ್ರು ದಿವ್ಯಾ ಇನ್ಫ್ರಾ ಅಂತ ಮಾಡಿಲ್ಲ, ಬಟ್ ದೇ ಅಟ್ಯಾಚ್ಡ್ ಓನ್ಲಿ ದ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದಿವ್ಯಾ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
It's made clear that the notice at annexure A
Party should be made Divya Infra.
relates to flat numbers 307, 309, 402, 403 and 404, which properties stand in the name of the petitioner,
Yes, ಮಿಲೋರ್ಶಿಪ್.
as is evidenced from the memo produced along with the list of documents. Which is that?
E-Khatas.
It is made clear that the order must be construed as being limited to enforcement against the petitioner and will not have the effect of proceedings to continue against Divya Infra. Full stop. For the purpose of clarity, it is to be observed that the notice seeking to enforce proceedings under RERA could continue against Divya Infra Properties Private Limited and the assets of the said company, as well as is permissible under law. The present adjudication is limited only to the petitioner herein and must not be construed otherwise.
ಮಿಲೋರ್ಶಿಪ್ ಅದು ಇನ್ನೊಂದೆರಡು ನೋಟಿಸ್ ಇದೆ, ದಟ್ ಮೇ ಬಿ ಆಲ್ಸೋ ಸೆಟ್ ಅಸೈಡ್. ದ
Your
ನೋಟಿಸ್
lordship,
ಅನೆಕ್ಷರ್ ಎ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನೇ ಅವ್ರು
Subsequent
2
notices
ಸರಿ
are
ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಮೇ ಆಲ್ಸೋ ಬಿ
Needless to state, any proceedings under RERA with respect to case number 626 of 2018-19 cannot be enforced against the petitioner herein. All rights of the third respondent are reserved to be enforced against the respondent in the RERA case. Accordingly, petition is disposed of. All contentions of R3 as against respondent in the RERA case are kept open.
My lords, here,
any existing
my
other notices
liberty
which
to
they have
approach
issued.
IBC code.
Needless to state, the third respondent is at the rights of the third respondent to initiate appropriate proceedings are kept open as is permissible in law.
Your lordship may clarify one line, my lord, where the numbers of the flats you said, it's in the building known as Divya Landmark Apartment belonging to the petitioner.
Flat numbers, so and so,
Flat numbers are
in Divya Landmark
apartments
Apartments,
belonging to the petitioners.
which belong to the petitioners. Now, these all are khatas with respect to the flats
Yes, Milorship.
standing in the name of the petitioner.
Yes, Milorship.
One sentence. The memo produced on filed on 4/6/25 contains details of the flats produced supporting the assertion of the petitioner that the flats ought to be attached stand in the name of the petitioner firm, which assertion has not been controverted. Yes.
Both petition club, both petition.
Same.
My lordship, 40.1 is also similar order, my
Both same, my
lordship.
lord.
Same
Both
order.
are same.
Both are same, only the,
Different flat numbers.
only the notice part is, reference number may be
Put it.
taken into consideration.
The same order may be.
No, just you can't say same order. You must tell me what it is.
Yes, my
Here,
lordship. Give me another petition. This one. Yeah.
similar order may be passed.
So your IA is to be allowed, isn't it?
It's allowed, my lords.
It's
Already
allowed, my
allowed.
lord.
40.1.
Yes, my lords. Both husband and wife.
Ah,
One,
IA allowed.
25, 8625.
Now in
Deep Kumar is the
8627, what has been challenged?
The same thing, my lordship. Idralli RERA order different. Ade RERA order different case.
Different
They have
amount.
filed two different RERA orders.
So where is the RERA order now?
Yes, my lordship.
That is also Annexure J. my
Page number 69, Annexure G.
60.
69, my lordship.
In WP 8627,
51 lakhs.
the petitioner, which is a partnership firm, namely Divya Constructions, has called in question validity of the order, validity of the communication at Annexure A, whereby properties of Divya Divya Landmark Apartments,
Order sheet allowed.
flat number 307, 309, 402, 403 and 404 sought to be attached.
Sir.
It's the case of the petitioner that the properties sought to be attached belong to are situated in Divya Landmark Apartments, belong to the petitioner and have nothing to do with the liability of the respondent in RERA proceedings. Where is that case number in RERA case number?
Page number 69, CMP number 180919 bar 1293.
In
8625.
PMP
8625. But
180919 /0001293. Full stop. It is submitted that the proceedings
Sir, one minute.
in the case are against Divya JSR Limelight
Yes, my lordship. It is against.
cannot be enforced against the petitioner, which is a different entity.
My lordship, this is against Divya Infra Properties Private Limited. Divya JSR Limelight is a project name, my lordship.
Against Divya Infra Properties Private
Yeah,
Limited,
yeah.
whose project is Divya JSR Limelight and has nothing to do with the petitioner hearing. Taking note of the observations made in WP while disposing of WP 8625 of 2022, adopting the same reasoning, present petition is allowed. The proceeding is against Annexure A insofar as it seeks to proceed against properties of the petitioner are set aside. Observations made regarding the rights of the petitioner complainant in RERA proceedings is kept open, and the observations made while passing order in WP 8625 2022 may be read along with this order. All contentions of the complainant in RERA proceedings are kept open to be and rights to be enforced as is permissible in law. IA 1 of 23 is allowed. This amendment to be carried out.
Divya Landmark belongs to the petitioner, my lordship. That
Yes.
line will be. Much obliged, Your Lordship.
Serial number 41, next matter. Next matter, my lord,
Mentioning it.
some difficulty.
Mentioning at 2:30, both sides want time.
Both sides are here.
You make a mention to the court, make a mention to the court office.
Your Lordship, mentioning Your Lordship, moving a memo for posting at the end of the list, Your Lordship.
What is
The
the
urgency in the matter is that I am a registered society, and from past 27 years, there has been no annual general body meeting which has been conducted. Now we have scheduled the annual general body meeting on 8/6. The president herein is trying to interfere to call off the annual general body meeting
Tomorrow.
only because it is
Tomorrow.
tomorrow. Much obliged, Your Lordship.
My lord, one memo.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಒಂದೇ ಒಂದು ನಿಮಿಷ
Lord, one submission, my lords, one matter, my lords. In this, my lords, Karnataka Information Commission has passed the order against a petitioner, my lords, without giving opportunity. Now
Tomorrow,
it is, my lords,
tomorrow.
tomorrow. Late till.
Lord. The judgment, my lord, paragraph 86, 87, 88. At page 96 and 97. Starts from 86, para 86. It is starts from page 96.
Yeah, read.
Please, my lord, 86.
Read.
Thus, what is discernible from the above is that it is duty of the courts to zealously protect the sanctity of the auction conducted. The courts ought to be loath in interfering with auctions, where otherwise it would frustrate the very object and purpose behind the auctions and deter public confidence and participation in the same. Any other interpretation of the amended section 13(8) will lead to a situation where multiple redemption offers would be encouraged by a mischievous borrower. The members of public would be dissuaded and discouraged from participating in the auction process, and the overall sanctity of the auction process would be frustrated, thereby defeating the very purpose of the SURFACI Act. Thus, it is in the larger public interest to maintain sanctity of the auction process of the SURFACI Act. In view of the aforesaid discussion, we will hold that, as per the amended section 13(8) of the SURFACI Act, once the borrower fails to tender the entire amount of dues, with all costs and charges to the secure creditor before the publication of the auction notice, his right of redemption of mortgage shall stand extinguished waived on the date of publication of the auction notice in the newspaper in accordance with Rule 8 of Rules 2002. Then thereafter, my lord, at para 105, at page 109. In that 105, at subpara 3, it starts from page 100, in that seventh line from the top. However, the amended before that they mention about section 38 prior to the amendment. Then post amendment, what is the position? However, the amended provision of section 13(8) of the SURFACI Act makes it clear the right of the borrower to redeem the secure asset stands extinguished thereunder on the very date of publication of the notice for public auction under Rule 9(1) of the Rules of 2002. In effect, the right of redemption available to the borrower under the present statutory regime is drastically curtailed and would be available only till the date of publication of the notice under Rule 9(1) of the Rules of 2002 and not till the date of completion of the sale or transfer of secured asset in favor of the auction purchaser. So, in this matter,
Let us have a look at section 13(8).
Please.
Read section 13(8).
The right of redemption of mortgage.
Section 13.
13(8).
Yes. Yes. Before the date of publication of notice of public auction. So now he has to pay the amount. He has to pay the dues before that date.
Please, narrate this. You are not able to.
Now what has happened in the present case?
But auction has been conducted on February 28, and the auction purchaser, successful bidder has deposited the amount of 25%, which being 21 lakhs. And by virtue of this order from this honorable court, we are unable to go ahead with the issuance of the sale certificate.
February 28th,
Please, madam.
28th,
28th of February,
this year.
this year itself.
He has deposited 25%.
Yes, madam. Being that is 21,06,600 rupees.
My lordship, till 27th March 2025, we have paid the EMI, my lord.
Correct, but now the NPA status has already been declared. So what we can do, and this is the law of the Supreme Court. I have no discretion in that matter.
My lordship, we are ready to repay entire amount, my lord.
But now it is already, now that right has been
The
extinguished now.
The petitioner, my lord, happens to be the co-borrower. Petitioner's husband was an ex-employee of the same financial institutions. So using that cloud, he delayed payment, not making payment. In between, he used to come and regularize also. So he used all the ways
Right.
so that to make some payment and not to make payment, delay the entire process for such a long period. And apparently, there is some kind of dispute between the co-borrower and the borrower, husband and wife. They are in the their matter is pending before the family court, is what I've been told. So in that particular realm, they are not making any payment, but they are frustrating the entire process. Now, wife is before this court, not the husband.
My lordship, more or less, we are records are there in the bank. If he is an employee, then also
correct.
he has to pay the EMI. So
No. Now, by virtue of the judgment of the Supreme Court, that right to redeem is lost. You have to take it up.
If
I
the
can't do
shooter
anything.
property goes out of the petitioner hand, she
No,
will put in a great hardship, my lord.
The court cannot do anything. Supreme Court has held that the right to redeem stands excluded once the auction notice is notified. I cannot go beyond that.
One submission, my lordship. They are due to their inconvenience between the husband and wife. Husband is not paying the EMI. That's it.
What we can
Now,
do,
petitioner wife is ready to pay that EMI.
you have to take it up. You challenge that order in accordance with law before the appropriate forum.
If once a sale certificate is issued, we
But
can't
what-
approach any court, my lordship.
No, forget sale certificate. Once notice is issued, your right closes. That's what Supreme Court has held. I have no discretion. I can't help you out.
Within sufficient time, we have filed the writ petition.
No, but I can't help you out. You should have gone under and challenged it before this. Once auction is done, there ends the matter.
Once the notice is issued, till 60 days, they have to give the time. Within that time period, we have approached the bench.
You should clear the dues as on the date of the auction notice. Once auction notice is made, Supreme Court says you can't do anything. Only you will have to take it up. That's all.
Till March, we have paid the. On April 1st only, we have filed the.
Correct. But now, once auction is done, we have no option to. Auction is
Last
made.
chance may be given for 2 weeks.
No, I don't have the power to do so. Supreme Court judgment. I can't ignore it. The petitioner. You have filed it in April. By then,
1st of April.
by then already the auction is done. Auction is conducted on
28th of February, 2 months prior to that.
the petitioner. There is no, what is the remedy in case no remedy?
Not either, if there is any infirmity, they can go before DRT, file an essay, challenge the entire process. They have that option.
If these petition
As
is
per the Securitization Act.
The auction proceeding.
Auction.
my lordship, one submission. If this petition is disposed, they will issue the sale certificate. Then we will lose our interest over the
You
property.
go
lordship.
before the DRT and challenge it.
Under section 17, they have an option to file an essay. A non-borrower also can approach DRT, challenging the auction proceedings.
Now, if I were to pass an order, then you cannot go there also.
Please. Only thing is they have to work out the limitation aspect.
Huh?
Limitation thing they have to work out to go before the DRT.
If this
That I
Uh,
can
matter is
say.
disposed, they know immediately they will issue the sale certificate. And then we will
Okay, now what I can do, you have to challenge the validity of it before the DRT.
That is the only appropriate forum.
You reserve your liberty, I will
no
keep
limit.
it.
We won't have that much time also, my lord. They will issue sale certificate by tomorrow itself.
There is no interim order now.
Yeah,
There is an interim order. Right? It was a conditional interim order.
No,
there is
that
an interim
order
order
goes.
with the condition to deposit the 5
Not been
lakh.
kept.
That order goes.
Yes, madam. They have not complied with it.
That order goes.
Due to some financial crisis only, we are not
No.
able to deposit the.
Correct. Now, so
Award
what
amount.
you tell me what you're going to do. If I were to pass an observation, your right is lost, then DRT also will repeat the same thing.
Yes, ma'am.
Otherwise, I'll say right is lost, close it, and say any infirmity is at liberty to challenge the
Yes.
validity before that.
Very well.
The
There will be no time limit for us also, my lord. Yeah, it's already expired. For us also, time is also already expired.
I'll say make an observation. Time spent here will be taken note of appropriately. I can say that much.
If my lordship give to at least 1 week time, we can deposit the.
No, that I can't do. I can't regularize that without the presence of the auction purchaser. I can't regularize that without the presence of the auction purchaser. We'll dispose it off or how?
Please.
The petitioner has challenged the auction notice dated 28/2/2025, whereby the date for auction was fixed at
20th March 2025.
20th of March 25. Full stop. Various contentions have been raised regarding reasons for default. Full stop. Petitioner further asserts that she was not informed about the auction nor provided a reasonable opportunity to repay the amount. Full stop. Next. Counsel for the respondent bank submits that auction was conducted on 20th of March
Please, madam.
2025.
Public notice was 28 February is notice.
Full stop. This court by order dated 2/4/25 had directed that if sale certificate was not issued, same was not to be issued till the next date. Interim order granted was extended time to time. Full stop. By order dated 25/4/25, interim order granted earlier was extended till the next date, subject to condition petitioner would deposit 5 lakhs into the loan account. Next. Admittedly, subsequent to the order of 25/4/25, petitioner he has deposited,
No, madam, nothing.
has not deposited any amount in the loan account. Next. Taking note of the law laid down by the Apex Court in CELIR LLP, Celir LLP versus Bafna Motors, Mumbai Private Limited and others. Civil Appeal 5542-5543 of 2023. It is submitted by learned counsel for the respondent bank that the right of redemption has been lost. Next, it is noticed that the auction purchaser who was the successful bidder has not been made a party. It would not be appropriate to pass any order without the said auction purchaser being made a party. Full stop. Next. Even otherwise, the remedy against such auction notice raising illegalities of the same, if any, is permissible before the DRT under section
17.
17.
Securitization Act, Surface Act.
Section 17 of the Surface Act. Full stop. Accordingly, we find no reason to continue the present proceedings. Taking note that the petitioner has not demonstrated bona fides by adhering to the condition imposed for payment in the interim order dated 25/4/2025. It is clarified that the petition is disposed of without entering into the merits of the matter, and contentions of the petitioner are kept open to be raised before the appropriate forum as is permissible in law.
Great.
Yeah. List next week at request.
I am for the petitioner. For the respond number 1 and 2.
Respond number 5, my lords.
On submission,
This
my
is a
lord.
petition.
One submission, one submission. My apologies. I should have filed it in the registry. Objections to vacating stay application. I served the copy on. R5 has filed vacating stay application. It has come up for that today. R5. Matter pertains to establishment of petrol bunks, whether it's in accordance with Ministry of Guidelines or not. If he wants to address argument on vacating stay application, let him address. There is a stay order.
So who are you?
I am the existing petrol bunk owner.
The neighbor, my lords. He's a neighbor,
Existing.
existing petrol bunk owner, my lords. Petrol, my
Three
lords.
tribal remarks.
Huh?
Near NHI, both are applying for putting up a petrol bunk. One is Nayara, he is Indian Oil Company. They got NOC from us. We have issued provision NOC, that is under challenge.
You appear for?
National Highway Authority of India. Respond number 1 and 2.
Now only, my lords, challenge the provisional, my
Great
lords,
rivalry.
NOC certificate issued by the NHA, my lords.
No, but what is your locus standi?
My locus standi.
Huh.
My locus standi.
If I find you have private business interest in opposing, you have no right. It's between
case
him
of
and.
No. I will convince your lordships.
So only point, my lords.
I will convince your lordships how I am aggrieved. This approval for establishment of petrol bunks is guided by the guidelines issued by the Ministry of Road Transport, Union of India. I have produced it at annexure D44. D44.
No, I'm
The-
saying
the
if it's a
questions-
public interest litigation. you challenge.
No. It is a private interest. My business is being adversely affected. I am supported by Supreme Court rulings on that. I will cite, I will come back to that, please, my lords. Page 44, annexure D. These are the guidelines which are issued, page 44. Lordship got
44, page number is.
guidelines.
Yes.
No, before that, I will come to that. Before that, please, my lords, I have to convince your lordships whether I am an aggrieved person, whether I have a locus standi to invoke Article 226, and whether I have a right to challenge the approval granted, whether I am an aggrieved person. my respectful submission to your lordship is, I was granted approval for this establishment of Petrol Bank on 26/6/2020 as per Annexure D. As per Annexure D, I have established. It is an investment of more than 2.5 crores, please, my lords. 2.5 crores, including site purchase of the site of the Petrol Bank. The next aspect, please, my lords, I would convince your lordship is, at the time of issuing this approval for establishment of my petrol bunk, the same guidelines were in existence. I have examined the viability, whether it can be established or not, and thereafter I have established investing such a huge amount. 56, lordship may kindly, in that guidelines only, page 56. Page 56. This is location 2.2. Lordship got it. Location norms on rural stretches of national highways. This is a divided carriage way. This is a divided carriage way on national highways number 75. Bangalore National Highway. This is. Lordship may kindly see the distance which should be maintained between intersection of the road and the petrol bunk.
Yes.
Distance of any intersections of any category of road and median gap is 300 meters. That is one point I am urging. Second point is distance between two fuel stations. Undivided carriageway is 300 meters. Divided carriageway is 1,000 meters. That is 1 kilometer. The only exception, please, my lords, is that if there were to be a service road not directly connecting to the highway, this can be relaxed. It is there. However, this restriction is not applied in case of access and egress for any such fuel stations as provided through common service road of 7-meter width and not directly to national highway. One is distance from the intersection of the road. Second is 1 kilometer distance from one petrol bunk to another petrol bunk. The main object and the purpose of the guidelines is to see the smooth flow of the vehicles on national highway, minimum interference to the national highway, prevention of frequent accidents. Now, my lord, what happened is, this very Indian Oil Corporation, it applies before this thing, National Highway Authority, for issuance of this thing, permission to establish a petrol bunk. That has been rejected once. Page 98, Annexure E, quoting this point only, same point, page 98. Page 98. Lordship, kindly go to 99. D. Lordship got
E.
D.
Page 98 is Annexure E.
Annexure E, my lords, in the
Annexure
class D,
EL.
class D is.
Annexure E, page 99.
98.
98 in start agutte. Next page alli ide operative with
Yes.
the relevant portion.
Yes.
How they have highlighted this and rejected it earlier. The MORTH, circular rated so and so, that is the guidelines, MORTH. Page number 23, serial number 2 of rural outlet in rural stretches has stated that the distance between the intersection with any category of road, median opening should be minimum 300 meters, wherein we have observed that the Tavrekere village road exists at kilometer number so and so, which is 65 meters away from the proposed retail outlet. Photographs from the site are enclosed for reference. Hence, it is herewith requesting to resubmit the proposal along with the revised drawings and checklist duly meeting the criteria to take further. Where is the question of resubmitting, please, my lords? Then also road was there. Now also road was there. 300 meters intersection. This is mainly because to prevent accidents. It is only 65 meters from the intersection of Tavarekere Road. And your lordship may kindly see the photographs which I have produced. Lordship may kindly see page annexure H page 105. 105. ಅದು sketch ಹಾಕಿದ್ದೀನಿ. Sketch ಹಾಕಿದ್ದೀನಿ. 105 sketch.
Is the central government a party?
No, my lord, National Highway Authority. I am relying on, I am not seeking any relief on this.
India also necessary party.
Annexure H.
Huh?
Union of India also necessary party. Ministry is required here.
Yes, you.
No, we are not seeking.
No,
any
you are
this
seeking
thing.
to enforce annexure D.
No, my lord.
Yes, yes.
No, we are not seeking. We are challenging the annexure, approval granted
Annexure
by
D,
this thing.
Annexure D is
Yes.
a restriction
Yes,
which you have relied on.
yes.
The interpretation of which must be done in the presence of Government of India. You implead them, I'll have it next week.
No, my lord, kindly.
No, what's the difficulty in impleading them?
There is no difficulty for me.
Let them
There
come.
is no difficulty for me.
Let them come.
I will include if that is the
If they
situation.
say it's not mandatory, there ends the matter. If they say no, it requires to be adhered to, NHAI is bound by it.
E-
Suppose the central government
No, why?
were to take a view that it is mandatory in the eyes of safety, there ends the matter.
My lord, the very guideline says this has been issued for smooth flow of traffic,
So let the
minimum
central,
interference from the public.
let them come.
I will do that. It is not a problem for
The
me
central,
because
the
Let's
government
us-
of
I am
India,
not, let's even his submissions, my lords.
the
I make-
government of India,
Let's,
Ministry of Road Transport and Highways is required to be arrayed as a necessary respondent as reliance is placed on the notification at Annexure D, which interpretation would have a bearing on the NOC given by the National Highway Authority of India. Full stop. The oral request to implead is allowed. Central government, Government of India, Ministry of Road Transport and Highways is permitted to be arrayed as a additional respondent. Central Government Standing Council to accept notice for the same. Copies of the petition and pleadings to be served on the said council. Relist the matter, necessary amendment to be carried out. Relist the matter week after next date code.
my lords, I am the respondent number 5, my lords. Since 1 year, my lords, already, my lords, the interim order kindly see, my lords, order passed by this honorable court.
Interim order
On my
is
lords,
there.
21st August 2024, my lords, in the interim order, my lords, the court held, my lords, I'll read, my lords, the interim order, my lords. The court held, my lords, the parties are directed to maintain status quo as of today. If the petrol bunk is not already established, my lords, in case, my lords, already petrol bunk is established. My lords, only now, my lords, we have to, my lords, get the final certificate, my lords. As per provisional certificate, you have, my lords, constructed the petrol pump, and my lords, we have invested a huge amount of 80 lakhs.
So let's decide.
Lord.
Now the question is whether it's a mandatory or only a guideline.
And my lords,
So if the
as saying, my lords, petition council, my lords, we have followed all the procedure, my lords. He's making false,
no.
my lords, as per his submission, my lords, between the my lords, village road to the petrol bunk is 67 meters.
He
My lords, there is no village road at all, my lords. It's a
Village road is
road.
what?
My lords, I have
National Highway authorities have said there is village road, and this man is saying that there is no village road. I have produced the photographs also.
I have filed the my lords statement of objections. My lords, kindly see the annexure, my lords, R4, where the my lords sketch prepared by the my lords surveyor of the my lords.
No, that depends on the stand of the National Highways Authority. If they have taken that stand, then
They have taken a
Here,
stand,
one submission.
65 meters ಇದೆ
Here, I would
ಬರೋದಿಲ್ಲ
like
ಅಂತ.
to make one
Resubmit
submission.
ಮಾಡಿ ಅಂತ ಹೇಳೋದು ಮತ್ತೆ ಕೊಟ್ಟು ಬಿಡೋದು.
Annexure A under challenge is that the letter issued by the respondent number, regional office of the NHI to the project director of Hassan, respondent number 2.
My lord,
Subject to that condition, provisional certificate, provisional NOC issued to the respondent number 5. After completion, they have to apply again for final NOC, then inspection will be there. By that time, if it is all the provisions are complied, then only we will issue final certificate. We only permitted them to construct building and everything. That's the
it's
reason they have invested them.
that's one submission.
After that,
premature
we also applied for one more trade license.
I have a
And
submission
it's
to
now
make.
just wait, please.
Nayara oil petrol company and something. Now, because of trade rivalry, they have filed this. Moreover, one more thing, my lord. They have filed earlier also one writ petition. Lordship, this honorable court directed me to accept notice. I have not been served with any copy of the notices. Thereafter, on the very same day, respondent number 4 herein, DC passed final certificate in final NOC in favor of the respondent number 5. Then they filed withdrawal application, but matter is pending also. I think that matter also not withdrawn.
Who
It has
has
become
filed?
infructuous, please.
Who has filed?
I have
Same
filed.
petition.
I have filed.
There is a petitioner.
It has become infructuous in view of Lordship may kindly see.
But that matter is still pending as far as website is concerned. I have not been served with any
WP number
2366 of ನಿಮ್ಮ objection ಇದೆಲ್ಲ
23
66.
26 of 2024.
that was
WP.
filed against which order?
This is the writ petition, please. This is the writ petition.
That was filed against which order?
It is filed.
I have not been served
praying-
with copy,
praying for a-
but
for a
pertain
direction
to
of
very
mandamus
same.
not to process their application. With abundant caution, I have filed it. The coordinate bench of this honorable court has granted stay of the process of the application of the third respondent on the very same day on which the stay is granted. Deputy Commissioner issues NOC, very day, same day. Lordship may kindly see the order also. I have a prayer, Lordship may kindly see.
Now, who has approached for NOC first?
Indian Oil Corporation.
Then
Respondent number 5.
I was
After
so-
that, they filed application for Naira petrol bunk
Petitioner.
petitioner. But
So
they
your-
have not
your
mentioned that
application
name
was-
individually they have filed.
your application was earlier in point of time.
Yes.
My lords, it's all earlier point of time, and this petition also, my lords, it's a premature petition, my lords.
2013.
After, my lords, we apply for, my lords, the dealership. My lords, our application has considered, and my lords, we have granted, my lords, permissions to, my lords, establish the petrol pump. As per, my lords, we are constructing the petrol pump, my lords. In meanwhile, my lords, after all completion of all the norms, my lords, we have to get the final NOC from the NHA and also, my lord, from the IOC, Indian Oil Corporation. But between this period, my lords, the petitioner herein is a neighbor. He is a rival, my lords, the businessman. He's before this court and taken the stay, my lords, suppressing the.
Correct. Now, the point is whether that guideline of the government is mandatory or it's only a guideline.
It's
Now,
one-
if the distance you are disputing, it's for the NHAI to take up.
As per
And my
the,
lords,
If the central government were to say it's only a guideline left to the to be taken note of by NHAI, there ends the matter. NHAI is
it is as per nomenclature says, it's only guideline,
It's
not
only
mandatory. Moreover, this petrol bunk applied by the Indian Oil Company, abutting to service road of the NHAI.
It's not exactly.
There
to
is
the,
no
NHA,
clear
my
case
lord.
of,
It's in the service
rivalry.
road. My lords, as per, my lords, the layout plan sanctioned by the DC, my lords, I'll place this.
no, we are only on the point. This is the only point, isn't it?
That is the only point. my
That
This
is
is
the
the only
only
point.
point. Another legal point I want to raise is whether promissory estoppel applies to this case or not. As on the date of granting of approval for me, I was 100% confirmed, no petrol bunk will be established 1 kilometer to the right side, 1 kilometer to
that is
to
not
the
there.
left side. That is a representation in the form of a guidelines. Apex court has
So
said.
that is against the central government. Central government is not a
No,
part.
National Highway Authority, public authority is also this thing. That is the reason I will make the ministry as a party. please.
My lords, whatever is.
Promissory estoppel definitely
No,
it is
no,
applicable.
you can't abuse the process of the court like this
No,
because of
I
your
am not-
private interest.
I am not abusing, please, my lords. With abundant caution, I have filed the earlier writ petition.
No, filing petition after petition.
No. I have filed a application memo for withdrawal of that thing.
Is it withdrawn?
I have filed a memo in the office long back. It has become
But
infructuous.
case is still pending, that's
No,
the website.
it is, nothing has happened. I have filed a memo. That memo has not come up before the court.
Yes.
That's all.
Still
It has
pending.
become infructuous.
Then why did you file the second petition? You should have
Because I have
amended.
said that in this petition. I have said that in this petition because it has become infructuous and he wanted to complete the work early.
Estoppel we'll see later.
Estoppel
So far as the,
definitely.
no, that we'll see later. Central government is not a party. Unless you make them a party.
I will
it's-
make him a party.
No, that we'll see. That's left to the court. Now you tell us factually regarding his assertion. His assertion,
Yes, my lord. I'll
what
make
do you
my
say?
submission.
Appendix 1, that it should be 1000 meters away and 300 meters away from the
Intersection.
intersection. What do you say?
But for that point, my lords, if my lords, if the petrol pumps are established exactly to the national highway, my lords,
if the petrol pumps are establishing in the service road, my lords, it will reduce to the 300 meters. In my case, my lords, in this petrol pump, it's a distance between, my lords, two petrol pumps at 550 meters. My lords,
I'll
can
have
you see
it
the-
next week. Let the central government come on.
Just to have to look, my lords,
Let the central government
layout
come.
plan, my lords, sanctioned by the.
No, correct. Let's see what the central government says. Relist the matter. You serve on the central government today. Today
same
itself.
My lords,
Same
shall I,
stage-
shall I,
same stage,
shall
my
I?
lords.
Same stage. Relist
may
the
be
matter
given,
on date. 12th.
Please.
My lords, I will implement the central government. as
Yes,
per
yes.
Your lordship's order.
Yes, you carry it out.
I will implement. And IO may kindly be extended, please.
Interim order in operation is extended till the next date. You serve immediately.
Immediately I will do it within one or two.
At request, relist the matter. Yes.
44, 44, 44, Suman Nagala.
D is under challenge.
My
brought,
lords, once,
I've complied with the interim order. I've deposited 96 lakhs, my lord, as
Nothing for
directed.
respondent.
What is this matter?
My lord, petitioner, my lord, is a partnership firm borrowed from the respondent financial institution. Lord, there was a interest created in a dwelling house. And my lord, the contention, my lord, is that there was a default and the account was declared as NPA. And my lord, there was no notice under 13.2. Directly, my lord, a petition is filed before the Lord civil judge and CJM under section 14.
You go before the DRT. I am not going to entertain.
One more submission.
My submission is this, my lord.
Yes.
I have raised issue of jurisdiction, my lord. There is
No, that we'll see.
No.
That you can raise there.
No, my lord, for a minute, my lord, I'll just point out that there is an assertion in page 42, kindly see page 42, my lord, in the order, that it was declared as an NPA in 2021 is a statement that is made, based on which, my lord, this my lord, 14 is initiated. Paragraph 4, page 42. 9/8, my lord, is supposed to be the date on which it is declared as an NPA. The alleged 13.2 notice, my lord, is 24/9/2021.
On?
24/9/2021, my lord, they say that they issued me a notice saying that the amount, my lord, to be paid is 1.98 crores. This was a long tenure loan, my lord, of 15 years. My lord, kindly now, my lord, see the statement which I have annexed as annexure C, page 31. Subsequent to this, my lord, for 2 and odd years, I have gone on paying, my lord, the EMIs continuously. They have accepted. Even if there was a declaration of an NPA in 2021, Lord, they have gone on, Lord, of course, my lord, few installments were due, which was less than 30 lakhs. That was because, my lord, the co-owner against whom this order is passed, he passed away. And my lord, there was some difficulty which was, my lord, for some time, my lord, there was difficulty because of passing. I have produced the death certificate, my lord, of at page.
I am not entering into all this.
No, page 50. No, this is an order passed against a dead person.
And there is no, maybe you raise that before the DRT. Don't convert the High Court into a DRT or DRAT.
Lord,
it's a complete abuse of process.
Lord, my submission is this.
The
court
has the discretion,
Lord,
no doubt,
there is an
regarding
order.
entertaining, but this kind of Supreme Court has said, and all of you want me to violate the order of the Supreme Court.
Lord,
it's a mockery of it. You take 25%, 4 weeks, 8 weeks, nobody pays.
No, I have paid, my lord.
Auctions are done.
Lord,
Sales certificate is not issued, despite Bafna's
Sir,
case.
there is no
complete abuse
there is no
of
sale
process.
here. Lord, there is no
You
sale
go
that
there,
has-
same relief you can
Lord,
ask.
My submission is this.
No.
Lord, kindly, Lord, hear me on this issue. Lord, this is a order that has been passed against a dead person.
Which order?
My lord, this order annexure D is, kindly see, my lord, page 56. Kindly see page 56. Date of death is 17/8/2023. And this order was passed on 27th of November 2024. To
Which order?
Annexure D, page 37, is 27 November 2024. Lord, apart from that, my lord, as directed by this honorable court, my lord, I
No,
have filed an
I'm not getting.
affidavit.
I'm not
I have
getting.
filed an affidavit,
Huh.
my lord, that I will, my lord, pay all the installments. I have complied with the interim order. There is a direction, my lord, that if I comply with this interim order, because what was due on that day was only 30 lakhs, they can regularize the, my lord, there is a direction that they could consider regularizing the account, my lord, and
No such direction should be issued by the court.
not my.
No. How can the
But
court
we
give?
will be in the difficulty, my lord.
No, that's your headache. Yes, what do you say?
My lord,
You appear for the bank.
yeah, my lord.
And now if he is going to do it, he says he's going to adhere to whatever conditions and he will regularize whatever default is there. What do you say?
My lord,
Account is already regularized. I paid
mortgage
60
property has
lakhs
been
more.
transferred to third party, my lord.
Huh?
Mortgage has been property transferred to third party, my lord.
When is that?
Yeah, it was.
Not third party, my lord, the deceased wife. It is transferred in the name of deceased wife, my lord. I have explained it in an affidavit. He
No, my
passed
lord,
away.
No, but what is now? What is your stand now? He's
My lord,
saying he will continue to pay whatever EMIs.
I'll take my instructions to with bank, my lord. Maybe I'll list it on tomorrow or tomorrow, day after
So
tomorrow.
what is your offer now?
My lord, 30 lakhs was due.
Hmm.
My lord, as per the interim order, my lord, the interim order said 45% of the entire, my lord, borrowed amount I have to deposit. My lord, instead of that 30 lakhs which was due, for which I have produced proof, I have deposited 96 lakhs.
Hmm.
My lord, it is regularized. They have 60 lakhs in excess as on today. 2 lakhs and odd, my lord, was the EMI. I have gone on paying the EMI subsequently also. My lord, the tenure was for another, my lord, totally 15 years, my lord, is the tenure. My lord, it would be 15 years was the original tenure, my lord. Whatever is, my lord, they have to just regularize the account, my lord. There was no default in this account at all.
So now you
Only
take
because of
instruct-
death, my lord,
Now
there
you
was
take,
some.
now you take instruction. If you impose whatever condition, he says he will adhere to it. If it suits you, well and good. Otherwise, we'll get into merits.
Okay, my
If
lord.
he's going to, he says he has made some advance deposit, etc. You look into it. If
Yes,
it
my lord.
suits you, you want to reschedule, it's up to you. It's between you and him. You solve it and you come back. We'll see.
Yes, my lord. Maybe day after tomorrow, my lord.
Relist the matter Monday or Tuesday.
My lords, one small submission, my lords. Our name is reflected as appearing for respondent number 2. Kindly request the court to strike off Mr. Vinagiri's name, my lords. We have not received papers or instructions to appear in the matter.
Who's R2?
RBI, my lord, because RBI is respondent number 2. I have relied on, my lord, the RBI's guideline with regard to, my lord, the manner in which annexure G. Therefore, I directed him as a party.
Office to delete the name of Vinay Giri for R2. Petitioner's liberty to serve papers on standing counsel.
There is no standing counsel for RBI, my lord. I'll
emergent notice to R2.
Yes.
What is this modification?
My lord, I
Extension of time.
No, all that is granted, my lord. I have deposited. Modification is, my lord, because the amount due was only 30 lakhs. I wanted a modification, my lord, because my lord, now I have complied with the original interim order. That may not survive.
Relist the matter on. But I am not going to take matters easily of surface. You have to go under the statute. All NCLT, NCLAT, all authorities. Now this court has been reduced only to surface bargaining, giving of installment. That is not, it may be convenient for the clients, but that's not the mandate of the law. Yes, next.
Interim order to.
Interim order in operation is extended till the next date. You sit and solve it with him.
Yes.
You reschedule it, ask him for rescheduling it, enter into a settlement and report.
Yes, my lord.
Look into it, whatever
Line in
suits,
the order, my lord, that
whatever
the
suits your
parties-
interest.
Parties are at liberty to, otherwise they will say pendency of the writ petition.
So needless to state, if the respondent finance, what is it? Financial institution
Yes,
uh, is at liberty to consider request of the petitioner for regularization and rescheduling of the loan as would meet the interests of the respondent bank.
good.
45, Sarita A.
Thank you for the petitioner, Your Worship. IA, my lord, that is dispensation IA. Production of the annexure H, Your Worship. The input order, my lord, they have sent it through the mail, my lord. So far as I have produced the Xerox copy of the same.
No, what is the matter?
I have challenged the, my lord, appellate order in annexure H, Your Worship. They have
Regarding
passed, my
transportation.
lord, two different order, my lord, in one appeal, my lord. That is, I have produced that annexure H and J. Same in appeal, my lord, two orders they have issued, my lord. There is in, my lord, in second order, my lord, in annexure J, one para is missing, my lord.
Annexure H.
H is, I am challenging, my lord. They have sent through mail communication, my lord. I have produced the annexure H1 is the mail communication dated 2/5/2025, Your Lordship. Appeal was disposed on 7/4/2025. They sent the message on, my lord.
Now this appeal was filed by you.
No, my lord. I am the respondent in that appeal. Appeal filed by the.
Appeal was filed by me.
Respondent number 2.
They have challenged the.
They challenged the, my lord, wholesale. They have we are not initially we are not party before the commissioner, my lord. Commissioner order they have challenged before the secretary.
Matter
Annexure D, my lord. D is the annexure D. Annexure D is the commissioner order, my lord. Food and Civil Supplies Commissioner, my lord. In page number 114.
Now you who challenged?
114. That is respondent number 2 is challenged before the.
Now what have they challenged?
They challenge, my lord. We are holding the that retail and also retail tender and as well as the wholesale tender. They are claiming, my lord.
No,
But they are not made as a party. Only the response is the party in that official response is the party in that proceedings, my lord. As per annexure D, parties is one is the DC and another one is JD, my lord. In annexure D, page number 114.
The challenge is to
They challenge the proceedings of the technical bid proceedings.
acceptance of technical bid of the
Technical
petitioner
bid.
was challenged by me, my lord.
but you have not made them a party.
No, in annexure H, kindly see, they are party, they have
Annexure D.
participated.
D, initially order is D, my lord.
Annexure D you have not.
They are not challenging that, my lord. They are challenging annexure H now. In
H.
that, they have participated in the proceedings also.
No,
H they have made
the
challenging.
order at annexure D was challenged at H.
Yes, sir.
Annexure D, initially I challenged the committee report,
that
accepting the technical bid. Subsequently, that was rejected and I preferred a second appeal before secretary.
No, but
And before secretary, they were heard and a detailed order has been passed now as per annexure H.
but without making them a party at the first instance, they did not have the benefit. They could have come on appeal. Now they have suffered an order at annexure H. If the same order was passed at D, they would have come and appeal. Now where is their appellate right? They are not heard at all when annexure D is passed. They would have had other contentions also.
On the date of
Annexure
argument,
D, they are annexure
because
D
my
was-
so many appeals are filed before the first respondent. He is not hearing any appeals, my lord. Suddenly, some of the appeals are posting or they are making the orders, my lord. On that day, my lord, our advocate is present on that day, but he seek for the time. But they have not given any time. But in that order, they have mentioned Vada Mandisidaru anta baridare. He seek the time, but they have mentioned that Vada Mandisidaru. Thereafter, my lord, order was passed on 7/4. They send it on, my lord, 2/5 through the mail. Thereafter, my lord, one in annexure J. Very same order, my lord, in that appeal number 180, annexure J. 136, my lord, it starts from 136. In 138, my lord, one para they have omitted, my lord. That para in 134, same order they have mentioned.
Affidavit of the secretary must be filed. And we will pass strictures. If orders are there, two orders, one ready, one not ready, this cannot be done, irrespective of the merits. Yes. Lord Counsel for the, and if we were to find any misgiving, you take it from us that we are going to pass strictures. The counsel for the petitioner submits that the appeal filed against the order of the commissioner at Annexure D before the secretary and appellate authority by the private respondent was disposed of by contradictory orders at Annexure H and J
Yes, sir.
with divergent conclusions.
Yes, sir. Please, my lord.
Full stop.
Conclusion is dismiss only, my lord, but one para they have omitted. The reasoning they have given. In same, my lord, they signed on the same day, but in that, my lord, one para is omitted in that annexure J.
My lord, annexure,
Conclusion is same, my lord, but para, my lord, they have sent
Correct,
through.
but then how are you prejudiced by this?
annexure
Because
D,
here, my lord, 7-4, how can they pronounce, my lord, two order, my lord, in the same appeal? In that, my lord, in the para, my lord, one para they have omitted and insert, they have in the annexure H, they have sent through May. They have signed it, my lord, they have signed in the bottom, my lord.
No, correct. What we are saying is,
Yes.
okay, we will ask him to explain.
Yes.
But how are you prejudiced? Because the conclusion remains the same.
This is not this is a non-speaking order, my lord. They have not come to the they have contention, my lord. We have participated in the retail transportation, but they have not come through that reasoning, my lord. There nothing is there, my lord, in that. Initially, they have taken that reason. In the after the J, my lord, in annexure J, that para is they have omitted, my lord. They have simply you have violated the conditions that regarding the experience. That experience, my lord, already stayed before this honorable interim direction is there, my lord. We can participate through. We have the fertilizer transportation experience. As per the direction of this honorable court, my lord, we have participated and we have doing the work. So many bidders also doing the work, my lord. Whoever is doing the fertilizer transportation work, my lord, having the experience in the fertilizer transportation. Here only they have taken in the subsequent order, they have taken only the ground that experience letter. That is not at all that is not at all the ground before the annexure D. Annexure D is not the pleading of the petitioner appellant before the commissioner in annexure D, my lord. Experience letter bagge, there is no pleading at all in the annexure D.
Let the entirety of proceedings be re-looked into.
my
Let
lord,
the
what-
entirety of the, see, annexure D was challenged by you.
yes, my lord.
Now the affected party, suppose it were to be allowed, would be the petitioner herein, isn't it? So let them be heard, you redo it. There are some procedural irregularities insofar as H and J is concerned.
Yes, my lord.
Let it be redone from the stage at annexure D.
Yes.
All contentions will be kept open.
Yes, my
The present petition has been filed.
Here what happened, my lord, they have
No,
not.
no, we'll send it back to the stage of annexure D.
Yes, because
You participate in the proceedings
yes.
and let all contentions will be kept open. Let them decide, you place your case before them.
Let my lord secretary, because my lord appeal, my lord, they are not disposing of the appeal.
No, correct,
Since
madam.
from 3 months,
Now
my lord,
we'll-
there is a direction from the High Court, even
No,
though they
we'll
are not.
send it back to the stage of
Let the
annexure.
secretary may explain it, my lord, how he has passed
No,
the
it
two
is-
orders in the single.
No, correct. Now that's not going to help your case. We'll set aside both H, J and D
Yes.
and revert it to the stage of D.
Commissioner.
Because here,
Commissioner.
my lord, respond number 6, the
No, no.
first petitioner is not party to that annexure D.
That's why we are saying annexure D proceedings
Yes.
will be done in your presence. So you go before the
My
commissioner.
contention, my lord, annexure D, they are challenging the proceedings of the technical bid, acceptance of the technical bid. In that, my lord, one party, that first petitioner is not ಇದಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ಲ ಸ್ವಾಮಿ. They are coming from retail transportation.
So that contention you raise it there on merits. Let it consider. I'll
Is it,
send
sir?
it back to the
First
commission.
respondent maybe explain it, my lord, how it is possible.
So that is of no consequence. We'll make an observation that this such procedure lab should not happen. But I'm saying your relief is almost granted because we'll give you an opportunity to go before the commissioner. That will be heard in your presence. You place your case.
Okay, now we are doing the transportation work since from 3 months, my lord, 3-4 months. Now we are doing, my lord, the transportation work as per the order of the technical bid committee and DC also, my lord. If this should
no.
not come in the way of that.
Now till an order is passed by the commissioner,
Yes, sir.
question of disturbing your thing will not arise. So there before the commissioner, his case will be heard. You place your contention. You will be arrayed as a party. Let him place it before the commissioner will take a decision in accordance with law.
But this is only the abuse of the process only, my lord, after the
No,
finalization.
we don't know the merits of his case. Why should we decide it here? You defend yourself. Defend it there at annexure D. We'll see.
Acha, please.
The petitioner has sought for setting aside of the order at annexure H passed in appeal number so and so, and has directed the respondents to proceed with the tender process. Full stop. It is to be noticed that the fifth respondent had approached the commissioner and appellate authority
Second respondent.
challenging the tender process. Challenging the tender process.
No, technical bid.
Technical bid.
Acceptance of technical bid proceedings.
Acceptance of the technical bid of the petitioner.
Challenging the acceptance of the technical bid.
Second petitioner, my lord. Only the second petitioners.
Second petitioner. The said appeal came to be rejected as per order passed at annexure D, which was subsequently taken up in appeal, and order was passed on 7/4/2025. By virtue of the said order passed in appeal, the grant of tender and acceptance of bid was set aside.
That DC order was upheld.
Was set aside.
That is set aside.
Full stop. The petitioner whose bid was accepted submits that pursuant to the tender, petitioner is proceeding to adhere to the tender conditions, and the order passed by the appellate authority through the Secretary, Food and Civil Supplies Department is riddled with procedural infirmities, as two orders at annexure H and J were passed with different contents. Further submitted that petitioner whose technical bid was accepted was not arrayed as a party in the appeal proceedings at annexure D
Before the commissioner.
before the commissioner. Full stop. Needless to state that proceedings before the commissioner could not have been entertained in the absence of the petitioner whose technical bid was already accepted as on such date.
Second petitioner only, my lord.
Full stop. The subsequent event would reveal that petitioner has been performing in terms of the tender. Work order and work order was issued pursuant to the same.
Annexure E is the worker.
Whether the subsequent events would render the proceedings itself infructuous is also a matter kept open to be decided by the commissioner. Taking
That
note
observation,
Huh?
that observation, if that
No,
is.
now at this stage, now how many months you have already?
That is only, they have already issued a settled mail, thereafter they come to with
Tender is for how many years?
2 years,
2 years.
my lord. From the day one, I am
No, no, how much?
litigating.
Correct. What is the time spent?
2 years, my lord.
2 years tender mail.
Out of that, how much?
4 to 2025 is our work order is issued.
4 to?
2025.
So now more than 1 year has lapsed. However,
Only 3 months, my lord. 25, my
4,
lord.
5.
no, 4 to 2025.
Ah.
That last sentence in ಅದು ಬೇಡ. ಬೇಡ ಅದು sentence ಬೇಡ. In light of the fact that the petitioner was not arrayed as a party before the
Second
commissioner.
petitioner only mail.
Second petitioner.
First petitioner is not a response. Not a.
Petitioner was not arrayed as a party in the proceedings at Annexure D, and noticing the procedural irregularity insofar as the order at Annexure H and J have been passed on the same day with different contents. The order at Annexure D, H and J are set aside. Matters remitted to the stage of appeal before the Commissioner, Food and Civil Supplies Department.
Yes, sir. Respond number 2.
Second petitioner is to be made a party, to be arrayed as a party in the appeal proceedings before the
No, both the
Commissioner.
petitioner will make, my lord. Because my contention is that both are brothers
Right,
and they are.
petitioners,
They are challenging
petitioners.
only the wholesale transportation mail. Acceptance of
I'm
the.
amending it, I will do it.
All contentions of the parties are kept open. Needless to state, in light of dispute relating to a tender matter, authorities to conduct proceedings and pass orders expeditiously.
Within 1 month, my lord.
That I don't know. 2 months. The commissioner, respondent number 2 is to decide the matter within a period of 2 months as regards the appeal and proceedings as reflected in the order at Annexure D, and conclude the same within 2 months. Yes.
Much of it. Petitioner should not be disturbed. Mail.
So that is there.
That is.
46.
Much of it.
And both the petitioners, my lord.
Huh?
My lord was very specific that only second petitioner has to be impleted. I want to implement both the petitioners because both are brothers and they are participating
They
in
are
the same
challenging the
tenders.
mail
And
wholesale
they are.
technical acceptance of the
will-
wholesale tender. Wholesale tender is different and retail is different mail. Both the proceedings are
Right may
there.
be not be
So whoever you want, you can implead.
that may be
Both
clarified.
proceedings there.
Liberty is reserved to the private respondent to implead appropriate parties as may be found necessary in the proceedings referred to above.
Including the petitioner number 1, my lord. Including the petitioner.
It
including
can't
the
mail
petitioner.
because mail he is the retail transporter.
us see, you can
They
take-
are the wholesale. They are challenging the proceedings is different mail. One
Then
proceeding.
why they are filing this
Now,
petition?
whatever contention you want on merits, you can raise there. Let him do it.
ಅಲ್ಲಿ ರಿಟೇಲ್ ಬೇರೆ ಹೋಲ್ಸೇಲ್ ಬೇರೆ
Let us
ನಮ್ಮನ್ನ
see.
ತಂದು ಅದ್ರ ಜೊತೆಗೆ ಅವ್ರು ಆಡ್
To
ಮಾಡ್ತಾರೆ
raise,
ಇನ್ಕ್ಲೂಡಿಂಗ್
raise the contention there. Yes.
46, sir. Ajay? Right. But I have a preliminary objection. Petition itself is not maintainable because final order has not been issued. Can I persuade your lords to look at my lord post judgments for my lord's consideration? This is covered by. Nodi.
Haven't even started,
I know. That's why I said preliminary objection to the maintainability itself.
but you've not raised it in your objections.
It is.
What are the facts?
May I just, there's a tender, my lord, for
Coal Transportation Agency. KPCL from Singareni Collieries, my lord. They want to appoint a coal transportation agency who will do all the licensing work, transport the coal and deliver it to Raichur RPCL, Raichur Power Company Limited, which is a subsidiary of KPCL. There are, as it is, my lord, two cover system. The first cover is a technical bid and the second is a financial bid. Now the technical bid, my lord, has been opened, and according to us, the respondent number 4, whom my lord, my learned senior friend represents, is not technically qualified. Subsequent to that, the financial bid was opened. Our stand was that you can't open the financial bid because he's not technically qualified. And therefore, my lord, we came and filed the present writ petition before this honorable court, challenging the action of KPCL in seeking to award practically now the contract in favor of the respondent number 4.
Was it awarded?
My lord, we don't know. They one stand of KPCL is, if I see the objections that they filed, they said no decision is yet taken. But the second stand is that everything that we've done insofar as the technical bid is correct, there is no infirmity in the decision that we've made insofar as the technical bid is concerned, because ultimately it will boil down only to the technical bid. And if the technical bid process is completed, then not the only thing left is the award of the final financial bid, which is to be done immediately thereafter. And it is not their position that they are still evaluating the technical bids and taking a decision on whether the technical bids are proper or not. And in our submission, the respondent number 4 violates 3 of the conditions in the bid itself.
No, but let's see what the KPCL says first, and then we'll come back to it.
My lords, I filed my objection. My lords, under the scheme of the KTPP Act, my lords, the tender inviting authority scrutinizes the bids. Once the tender inviting authority finds that the bids are scrutinized, he will then process it to the tender scrutiny committee. Tender scrutiny committee will recommend opening of the technical bids. Thereafter, technical bids are opened. After that, there's a final evaluation which is done, which is then placed before the tender accepting authority. The tender accepting authority is to then take a decision. The situation right now is the tender scrutiny committee has recommended, and on the basis of that, the financial bids are open. On the basis of the financial bids being opened, the petitioner is about, my lords, 63.64 crores. The difference between the petitioner and respondent number 4, who is the L1 bidder, is 63.64 crores. Now, my lords, the final decision insofar as this aspect is concerned would have to be taken by the tender accepting authority, which decision is not yet taken.
Which decision?
Now, the difference in the sense of the financial bid of the petitioner and the
financial
respondent have a difference of
63.64 crores.
So who is the lower one?
Respondent number 4 is the lower bidder. Now, the petitioner, my lords, is the current incumbent person who is carrying out the work.
No, now we don't know what is the decision finally to be taken. We don't know.
No,
we don't know. They may decide to accept yours also. We don't know.
No, he's accepted. He's L2 bidder. Petitioner is L2 bidder.
The technical bids stage is completed. It is only after the technical bid stage is completed that the financial bid can be opened.
No, correct. Now the financial bid, whatever offers have been made, we don't know what is the decision now.
No final decision has been taken. Final decision in terms of section 14 of the KTPP Act is not yet taken.
No, correct. Now that decision need not be necessarily on the higher and lower.
Yes, my lord, the discretion is entirely vested. Yes.
Theoretically.
Yes.
Theoretically, it's open even if it suits you to choose any one of them.
Yes.
So then it would be premature.
No, yes, and identical situation, my lords. This honorable court has held. My lords have produced the judgment at page 19. Insofar as KPCL is concerned itself, it was complete Tata Projects case, my lord. I think, my lords, Learned Senior has also produced it, my lords. As
We are at the stage where we are saying that
Why is
the financial bid of a person who's not technically qualified could not have been opened. We are at that stage. My learned friend is saying financial bid under the KTPP Act, we will take the lowest bid.
We don't know.
No, it says so. The law itself says so. Please see section 13 and 14 of the KTPP Act.
But that's not mandatory.
No, it is.
We don't know what goes out in finally deciding which bid has to be accepted.
Yes.
No,
Theoretically, it's open. There's nothing.
But if it is the question of evaluation of only the financial bid, that is one issue. The question in my humble submission is whether you could have opened the financial bid of the respondent number 4 at all. We are at that stage where we are saying that he is not technically entitled to be.
Same exercise you can repeat once the final decision is taken.
No, but I can't.
Why not?
Because the final
keep
decision.
it open. We'll keep it open.
But
we'll keep it open. Same issue, you raise it then. How do you know that yours may not be accepted?
But I'm saying you can't open the financial bid of the respondent number 4. Ultimately, in opening of financial bid, there is a stage. You must technically qualify in order to have your financial bid opened. I'm at the stage when I'm pointing out to my
Will
lord.
merge with the final order only.
Beg your pardon, Lord?
It will merge with the final decision taken by them.
No, it actually
take a
Yes,
decision.
my lords, the rule is
stages.
very clear, my lords. I have to place an evaluation report consisting both of the technical and financial detail. I have to place both before the authority.
So it's still theoretically open.
It is open, my lords. Not as per law, it is open, my lords. Whatever decision has been taken by KPCL, the tender inviting authority and the tender scrutiny committee as on date can be reversed by the tender accepting authority.
Where is that? Just tell me the procedure.
My lords may kindly take rule 24 for a minute, my lords.
Of
KTPP rules, my lord.
Rule
24 minutes.
Yes.
My lord, see rule 24(1), my lords.
Yes.
Tender inviting authority shall cause an initial examination of the tenders submitted to be carried out in order to determine the substantive responsiveness. During initial examination, the following factors will be considered, namely whether the tenderer meets the eligibility criteria laid down in the tender documents, whether the crucial documents have been duly signed, whether the requisite earnest money has been furnished, whether the tender is substantially responsible to the technical specifications set out in the bidding documents, including testing. The tenders on which the initial examination are found to be not substantially responsive under any of the clauses under subrule 2 may be rejected by the tender accepting authority. That stage comes in rule 26. My lords may now see rule 25 for a minute, and then I'll take my lords to rule 26. And all of this is explained in the judgment. I'll take my lords to judgment also after.
Yes.
Rule 25 says, out of the tenders found to be substantially responsible after initial examination. Initial examination is by the tender inviting authority. The tenderer who has bid the lowest evaluated price in accordance with the evaluation criteria, or the tenderer scoring the highest on the evaluation criteria, may be determined. In determining following procedures, my lords, that for the time being may not be relevant, my lords. Then, my lords, after all of this is done, my lords may now come to rule 26.
So under 25(1).
25(1) is what I read, my lords.
Yes, under 25(1).
Yes, my lords.
Either the lowest bid or tenderer scoring highest on evaluation criteria.
My lords, it depends on the type of tenders. For example, my lords, there will be there are two-stage tenders. Two-stage tenders, my lords, are tenders where I will only give the qualifying criteria. Price bid I will call at the second stage. That is that situation is contemplated here. All of this is initial examination. After this happens, my lords may now look at rule 26 for a minute.
Yes.
Preparation of evaluation report and award of tenders. Tender scrutiny committee or the officer inviting tender shall prepare a detailed evaluation report which shall be considered by the tender accepting authority before taking a final decision on the tender. Now, my lords, if my lords were to now read 25(1) and 24(2), 24(2) and 25(1) is based on initial examination, which is done by the tender inviting authority and the tender scrutiny committee. The final decision in terms of 24(3) is taken by the authority under 26(2). That is a tender accepting authority. Tender 26(1).
So the tender scrutiny committee takes the final call.
Tender accepting authority. Can I just read 26(1) for a minute, my lords? I'll just explain it just 1 minute.
Yes.
My lords, before that, can I just take my lords to the definition of the tender accepting authority and the tender inviting authority for a minute, my lords? My lords, section 9, my lords, basically. Section 9, my lords.
Yes.
Section 9, my lords, defines the tender inviting authority. The procurement entity in this case would be KPCL, my lords. Section 9. May appoint one or more officers or a committee of officers to specify to be the tender inviting authority for any specified area, specified procurement, etc. Then similarly, they will appoint one or more officials to committee of officials to be the tender accepting authority for a specified area or specified procurement, specified class of goods, etc. So tender accepting authority is different, tender inviting authority is different. Tender scrutiny committee comes wherever the contract value is more than 5 crores. That my lords will find at section 10.
Yes.
Section 10, my lords, the tender accepting authority may constitute a tender scrutiny committee consisting of such persons as it deems fit to scrutinize the tenders above 5 crores in the case of public works, irrigation, minor irrigation departments of government, and 1 crore above in other cases. So, my lords, there are three authorities totally, my lords. The final decision in relation to acceptance of tender, my lords, is taken only by the tender accepting authority, which my lords will find at page number section 13, my lords.
Yes.
Section 13, my lords, says the tender accepting authority shall, after following such procedure as may be prescribed, pass order accepting the tender and shall communicate the information relating to acceptance of tender together with comparative analysis and reasons for accepting a tender to the procurement entity. Now, my lords, this rule, section 13, has to be read with rule 26. Now, if my lords were to look at rule 26 in this context.
Yes.
Rule 26, my lord, says preparation of evaluation report and award of tender. The tender scrutiny committee or the officer inviting the tender shall prepare a detailed evaluation report which shall be considered by the tender accepting authority before taking final decision on the tender. Subsection 2, the system shall auto-generate system of statement of evaluation along with comparative statement. 2A, tender accepting authority shall pass suitable orders after evaluating the tenders as per Rule 25. Now, my submission, my lords, is that the tender accepting authority today has not taken a decision. The decision has been taken by the tender inviting committee, tender inviting authority, and referent by the tender scrutiny committee. Now, the order thereafter will be coming.
So theoretically, is it open for the tender accepting authority to enter into the technical bid as well? To enter into the technical bid as well.
Yes. Tender accepting, my lords, tender accepting authority has to look into that because my lords may see it is obvious from the section itself. 24.3 tagondre 1 nimsha. 24.3.
Rule 24.
Sorry, Rule 24.3. I'm very sorry. Thank you, sir. Rule 24.3.
This is only a formal scrutiny, you're saying.
No. Initial scrutiny is by tender inviting authority.
Correct. So
the actual order, rejection order, has to be passed by the tender accepting authority.
So they may choose to decide either way.
Either. And my lords, this, my lords, is the settled position of law, my lords. Tata Chemicals is there, my lords. Tata Projects, I'll just show the judgment.
No,
I want to say something.
No, just if that is their stand, then all the contentions will be kept open.
If that is their stand,
if that is their stand, and we were to
then that stand is contrary to the tender document itself.
So that we'll see, we'll record it. There ends the matter. Now, finally, the ball is in their court, finally. So if they are deciding that I'm going to follow this procedure, so be it. For the time being, we'll say that that is the procedure. It will be kept open. We'll see what happens, and then you come back.
Can I make one submission? Please come to page 96, not of the tender documents. My learned friend argued on all of these things, but please see his tender document. This is, my lord, the heading, tender opening and evaluation. My lord has that?
Yes.
Clause 19.
Yes.
Yes. I'll just read this, my lord. RPCL, that is the tendering body, will open the electronic document number 1, part 1 of all the tenders qualified for the same in KPPP in the presence of the tenderers or their representatives who choose to attend at 1100 hours on 7/3/25 at office of so and so. In the event of the specified date being declared a holiday, tenders will be open on next working day. In KPP, a tender has the option of withdrawing the tender bid. I won't trouble you lordship with that. 19.3, they should have submitted the requisite EMD. Then, Lord, 19.4 now, and that becomes important. Electronic document 2, part 2 of the tenderers shall not be opened in KPP till the evaluation of tenders in respect to electronic document number 1 is completed and approved by the competent authority. Therefore, my lord, the price bid can't be touched until, my lord, it is approved by everybody. Then please see next 19.5. RPC will evaluate and determine whether each tender meets the eligibility criteria determined in ITT clause 2, is accompanied by the requisite earnest money deposit, meets the minimum qualification criteria stipulated in ITT clause 3. Accordingly, RPCL will draw out a list of qualified tenderers. This process has to be completed fully first. My learned friend says price bid can be opened. This also can be seen. Then please see next one. Opening of electronic document number 2 of qualified tenders and evaluation. RPCL will inform all the qualified tenderers the time, date, and venue fixed to the opening of the electronic document 2, which incorporates the price bids, price tender. RPCL will open the electronic document of all qualified tenderers at the appointed time and date in the presence of the tenderers or their representatives who choose to attend in the event of it being so and so. Then, Lord, the tender's name, tender price, total amount of each tender, and such other details as considered appropriate will be announced by RPCL at the opening of the tender document. No tender shall be rejected during the time of opening of electronic document number 2 of the tender. The process, my lord, that they have called upon, they have put in place for themselves is first initial examination.
But then this is apparently in contradiction to the rules.
It is not, my lord. It is not. This is the process which has always been followed in KPCL. As a matter of fact, in all 2 cover tenders, the first is financial evaluation and qualification to be taken into consideration to determine who is entitled. If you don't make that matrix, then to open a bid, my lord, a financial bid is very dangerous because you'll open the financial bid of a non-qualified tenderer. You'll open
that initial scrutiny is only a formal scrutiny.
It is true. Now please see that. We are not talking of initial scrutiny now. We are speaking of 19.5, which is the final scrutiny and evaluation. Now please come to clause rule.
No, but how are you now prejudiced? Let the final decision come, then we'll enter into. We can't keep interfering.
I'm saying my learned friend submission is contrary to his tender document.
Maybe, but if this is the procedure which we take on record by way of a memo, there ends the matter.
No, my lord. Respectfully, if the terms of the game, my lord, have been specified in the tender document, KPCL at least cannot come before your lordship and say we are doing something contrary to the law.
We can't enter into all that. The only point is they're saying this is the procedure. How are you prejudiced by it?
I'll tell you lordship what the prejudice is.
We don't know.
No, there is prejudice.
No, where is the decision taken?
There is prejudice. Let me explain why the prejudice is. If you open the bid of an unqualified tenderer, that is a prejudice, my lord, to me. You open the bid of an unqualified tenderer and then you say now there's price. And on the basis of that price, you then adjudge everyone else's prices. That is prejudice to me. Which is why you have a clear, definite 2 stages in every tendering process, where first you determine qualification, then you determine price. You only open tenders of those bidders who have qualified. You can't open, and I've never seen a scenario where any court has permitted a non-qualified tenderer's bid to be opened, evaluated, and then a final decision taken on the technical bid. That can never happen. It always has to be the 2 first stages. Technical evaluation is complete. First is initial responsiveness to the tender, where the tender accepting authority will simply look at whether all the documents which are required to be part of the tender is there or not. Then they drop a process memo where everything is ticked off. Then it is submitted to the scrutiny committee who will evaluate it. And once that evaluation is done, the competent authority will take a decision as to whether a particular person is qualified or not.
If the technical bid, after a formal perusal, is found to be defective, let's assume, the tender accepting authority, which is the final authority as per the scheme, may still consider that the defect could be overlooked?
Yes, yes, it has happened in the past also where, my lords, bids. So the tender, my lords, it's happened in one particular scenario, my lords. What had happened at that point in time is that between the time from the tender inviting committee's report to the matter being placed before the tender accepting authority, some additional information came to light. Basis the additional information, clarifications were sought, etc. Writ petitions were pending. During that time, my lords, the tender accepting authority has said that the order passed by the tender accepting authority is incorrect. In fact, my lords, but relating to this tender itself, my lords, what had happened is that previous round in which, my lords, the petitioner was L1, what had happened, my lords, was that the tender accepting authority itself had passed an order rejecting the rejecting the bid of the respondent number 4 hearing on the exact same grounds on which the petitioner is now seeking to seek rejection of the ground. This honorable court said, no, first open the bid. Based on the direction of this honorable court, the tender accepting authority directed the tender inviting authority to open the bid. Bid was opened, placed before the court, found that he was L2 bidder. On that basis, that writ petition was disposed of. It can happen. And the tender accepting authority has full discretion to do it because ultimate final decision is with the tender accepting authority. So on this aspect, page 51, my lords, the judgment of our High Court is there.
There are judgments not directly on this issue as to whether a financial bid can be opened before you determine before you qualify a tenderer, whether a financial bid can be opened or not. I'll place those authorities then before your lordships. Lordships may have it tomorrow. I'll place those authorities. This has been done several times. You can't open the bid of an unqualified tenderer. My learned friends, innovative argument now to say that the tender accepting authority can alter the decision, in my humble submission, is incorrect. I'll show you lordship's judgments directly on this.
No, I'm not saying alter decision. Take a decision. I'm sorry. My lords, let me correct myself. I said take a decision because the tender inviting authority cannot take a decision. It can give a report.
Never said tender inviting authority can take a decision.
I said take a decision.
Lord, the point is tender inviting authority will only determine responsiveness. Scrutiny committee will make a complete evaluation table where everything is evaluated, and then it is placed before the accepting authority, who will then say, yes, these are the qualified bidders. There may be 10 bidders, 3 may qualify. Out of that, then they don't open the 10 bids. They only open the 3 bids. Then, my lord, they cannot turn around and say, now I'll go back 3 steps and now look at whether the evaluation is proper or not after the price bids are opened. If my lord, an authority is required for that, I'll place it before your lordships.
But
on this, directly on this point.
Directly, my lord, please come to my lord, my judgment compilation and give it to your lordships. I'm sure my learned friend is aware of it. When he was this side, my lord, he was citing all this.
No, I have not
please
cited all this.
Please come to my lord page 7 first. Sorry, page my lord 50. That was the first judgment rendered by Justice K.S. Bopal. Please come to my lord page 50. Paragraph 8 at my lord running page 53. Since the threshold contention with regard to the petitions being premature and not maintainable is very strongly urged by KPCL, the said question is to be considered at the outset, as it would result in a situation of there being nothing more to examine on the merits at this stage. The contention is accepted. On the other hand, if any further consideration of the matter is required, KPCL would have to be provided an opportunity of being further material, to bring further material on record. Then please come to paragraph 15. Next page. A cumulative perusal of the decision, his lordship refers to various judgments, including that of the Supreme Court. A cumulative perusal of the decisions relied upon by both sides would indicate that the overwhelming opinion is that the court will not interfere unless the cost to do so has arisen. That is, until the decision one way or the other is taken by the competent authority who is required to take decision, and such decision is in favor of one and has affected the other. In case of Siemens, though the Honorable Supreme Court examined the matter, it did not interfere, though on the opening of the bid, petitioner therein who had quoted the lowest but was not treated as L1 after evaluation. Honorable Supreme Court has no doubt held that the judicial review is possible when the decision-making process is so arbitrary or irrational. In the said case, discussion with the petitioner was excluded. However, in the instant case, evaluation was made by the committee itself, taking note of the requirement and the bids made, and thereafter the discussion has commenced with L1. But the other tenderers have not been rejected. Therefore, on opening of the bids, Evaluation procedure has been the same for all. Though there is serious dispute with regard to the method adopted in arriving at L1 by applying different standards of discounting and loading for different tenderers. That aspect of the matter, no doubt, would arise for consideration only after evaluations and negotiations are complete and a decision relating to acceptance of any tender is made. Any examination at this stage based on apprehension is only fishing for discrepancies, since petitioners are also contending based on reliable information and not on concrete material. Further, unless this court comes to a conclusion regarding the imminent necessity of probing the matter further, it would not be necessary for KPCL to divulge any further details at this stage, since the process is still underway. In the decision, in the case of Ganapati,
just one.
Then, my lord, that was, my lord, they refer to, my lord, Ganapati Italier's case. That also is considered. Then please come to para 21 now.
Yes.
The combined reading of all decisions on different points referred above would boil down to the position that, as a rule, courts would not entertain petitions when no decision has been taken by the competent authority affecting the right. Exception, however, would be when it is shown that the decision-making process itself is so arbitrary and irrational that no authority acting reasonably will take such decision to the extent it is taken. Even in such a case, courts should only peruse the decisions taken by the experts in the field to exclude arbitrariness and unreasonableness, if evident on the face of it, but would not substitute its opinion for the expert's opinion and step beyond institutional capacity. Mere deviation or relaxation of price difference should not be the basis for interference, as the same are also permissible. Depending on its nature, interference should only be where if there is substantial public interest. When that is the yardstick to be applied to examine the decision, even at the stage when the awarding of contract is complete, interference with the process is still going on, should be with greater restraint and minimal. Then, my lord, more importantly,
Para 27.
Para 27, correct. Last one. Next page, last page. In the above background, statement filed by KPCL would disclose that only on the opening of the price bids of all the 4 bidders, all of them have been evaluated, and an evaluation report was prepared, which was examined by the tender scrutiny committee, and along with this report, it was put up to the technical committee. Further, evaluation made was also got verified by an independent firm of chartered accountant. All the evaluations reports have been placed before the tender accepting authority, which is the board of directors, and further procedure is underway. Learned senior counsel for the petitioners, while referring to the averment in the objection statement and recording in the board of meeting dated so and so, sought to contend discussions with regard to the technical and commercial deviations after evaluation tenders would not be sustainable. Despite the same, keeping in view the deviations being alleged against one another, and also taking note of the fact that all tenderers have been evaluated, if at all there are any errors in the matter of evaluation, and if judicial review is necessary, same would only be made in an appropriate proceeding at an appropriate stage, and not when the process is not yet complete. This is one. This is, my lord, followed. Please come to, my lord, turning page, my lord, 7. In this, please come to, my lord, paragraph 5 at running page
16.
16, my lord. 1-6. Respondents have filed objection statement and at the first instance had contended the writ petition is without cause of action and is therefore premature. as no action has been taken at their end. In that regard, reference is made to Rule 24 of the Karnataka Transparency in Public Procurement Rules 2000, which provides for assessment of the tenders. And it is stated that the evaluation was yet to be completed. Thereafter, when the evaluation was made and when the technical bid of the petitioner was rejected, petitioner has filed the application for amendment. Objection is filed in that regard. My lord, in that case, rejection, my lord. Tender, my lord, technical bid was rejected. Here, my lord, it is accepted. Permit me to read further. Thereafter, when the evaluation was made, when the technical bid of the petitioner was rejected, petitioner has filed an application for amendment. Objection is filed in that regard, and it is contended that the petitioner, if aggrieved, is to avail the remedy of appeal as provided under Section 16 of the Karnataka Transparency in Public Procurement Act of 1999, and that the writ petition is hit by the existence of an alternative remedy. It is therefore contended that under any circumstances, writ petition is premature and judicial review is not permissible at this stage. The manner of tender evaluation made by the committee is also referred, and the reason for which the petitioner was found not qualified in the technical evaluation is also sought to be justified. Now, my lord, please come to my lord paragraph 20, 14 and 20. First 14, 1-4. In fact, my lord 11 only, earlier judgment of Tata, my lord, the projects is referred to page 20 ಬಂದಿರತಾವು 20ರಲ್ಲಿ. Tata projects, my lord, is referred to in paragraph 11. I'll leave it at that, my lord. I've read, my lord, those. I'll not trouble your lordships. Please come to, my lord, page 29, paragraph 14. Therefore, to place the matter in its correct perspective, it is reiterated that the writ petition under Article 226 of the Constitution cannot be treated as the only remedy for all ills, more particularly in the matters of contract, where the tender process is still under progress and is regulated by statutory provisions. My lord, please mark this again. Regulated by statutory provisions. Technical evaluation of the bids is in fact the first stage of evaluation, which will normally be done by a committee of experts in the field based on tender conditions and after evaluation material produced to satisfy the conditions. In that view, in every tender process, there will be at least one aggrieved tenderer if they are found to be not qualified, unless in a rare situation that all of them qualify in the technical bid evaluation. No tender process will conclude if this court begins to interfere at every stage without restraint to undertake the exercise of judicial review, unmindful of the circumstances. Aggrieved party in any event is not without remedy, since the such party is provided remedy of appeal under the statute to be availed at the appropriate stage. In the instant case itself, it is noticed that the stipulated period for completion of the work under the short tender, so and so, is 18 months. Then, my lord, they skip this. Now, my lord, please come to paragraph 20. 35, my lord, page 35. Further decision of this court in the case of South India Corporation, Karnataka versus Karnataka Power Corporation Limited and another, relied upon by the learned senior counsel with the respond number 1 and 2 is also relevant. In that case, this court, with reference to the order passed in Tata project, had kept in view the procedure contemplated in the Rule 25, 26 and 28 the KTPP rules, and in that context had arrived at the conclusion tender process cannot be considered as concluded till the tender accepting authority takes a final decision in the matter, and interference at earlier stage will amount to prejudging the issue. If all the above aspects are kept in view, I find that there is no cause made out for the court to exercise its discretion, so on, so on. In this, my lord, I had appeared, my lord, for the petitioner, my lord, and argued, my lord, vehemently, like what, my lord, my learned friend is doing. Now, my lord, please come to page 37.
My case is slightly different.
All right, of course. When I come there, I'll also say the same thing. I did say that last time. Page 37, lord, is 2019 judgment. Please come to paragraph 4. At, my lord, running page 37, beginning of the page itself, that 37. This petition under Article 226 of the Constitution has been filed by the petitioner being aggrieved by the decision tender inviting authority, respond number 1, to proceed to take steps towards awarding the works under the request for proposal for selection of local system integrator for implementation of the integrated command and control center, smart elements in Shimoga, dated so and so. In order to appreciate the petitioner's grievance, relevant facts need mention, which are stated as hereunder. Para 16, my lord, now your lords may come. At running page 46, my lord. Thus, from the narration of facts, it is evident that the decision of respondent number 1 to award contract to respondent has been taken bona fide in public interest. It is pertinent to mention that in this petition, neither the members of the committee nor any members of the management consultant have been implicated as so and so, so and so, my lord. They refer to all that. Then, if your lordships come to, my lord, page 19, on paragraph 19. Sorry, para 5, my lord, if your lordship sees, contention was, my lord, that the commercial bid ought to have been rejected. My lord, your lordship may not turn the page, my lord. I'll just, my lord, I'm mentioning it. Please come to para 19. Then, my lord, their lordships, my lord, hold that, my lord, efficacious alternative remedies available. So all that I am saying, my lord, is this. Ultimately, my lord, this is a premature stage. That's why, my lord, initial stage itself. And my learned friend said, I have not raised it. Please look at paragraph 3. I'm sure, my lord, my learned friend has not read my objection statement. I have specifically contended that the present appeal is not maintainable.
So just one clarification.
Not maintainable.
It's their contention that if you don't cross the stage of technical bid, question of considering that person for the second financial bid doesn't arise.
My lord, my submission would be, look at the, my lord, rule 26, 24.3, 26, 24.3, my lord, it's only an initial, my lord, examination, not, my lord, a final exam. Whatever, my lord, the contract may say, my lord, ultimately all of us are bound by the statute. Therefore, it is not, my lord, open to my learned friend to say, well, that is final. No, ultimately, my lord, they'll have to take the call. That is one. Second, more important is, please look at my objection statement. On an earlier occasion, previous time, my lord, he was awarded. Now, my lord, the whole game plan is, he says, my lord, in his own petition, he says, till, my lord, all this is done, please continue, my lord, me to continue the work that I've already been doing. Now, please look at, my lord, the earlier order passed by my lords at page 27 of the objections. My objection statement. Objections filed by respondent number 4. Sorry. Heard the senior counsel? For the my bid was not opened at that time. On the same ground, my lord, which they were now, my lord. Page 27 of the objections of, my lord, respondent number 4.
It wasn't opened last time. Last time he was disqualified. This time also he has to be disqualified. But last time they don't open the bid. This time they open the bid. How is it possible, my lord?
My lord, last time, my lord, this court directed it to be open. No. Let it find, my lord.
But doesn't matter. What I'm,
my lords, because my lords,
they didn't
both
open
of them may change side this side. I have always been on this side only, my lords, and I can tell you very confidently what happened in that case.
Please look at it, my lord. Heard the senior counsel was the petitioner. Learned counsel appearing for the respondent. This is, my lord, if you allowed to look at, my lord, the top. Kamarchand, my lord, Thapar. Karamchand Thapar, my lord, is the respondent number 4. He was the petitioner therein. Petitioner bid application. Second paragraph. Pertaining to the tender notification dated 25/1/24 is not considered on the ground that the petitioner has incurred a debarment in respect of another bid pertaining to the tender called on the ground that the petitioner has incurred a debarment in respect of another bid pertaining to the tender called by Bokara Power Supply Company Limited, Jharkhand. Petitioner's grievance is that the said order debarment was on account of error in mentioning the price bid. High Court of Calcutta, taking cognizance of this discrepancy, has, however, stayed the order of debarment. Counsel for record has brought to the notice of this court that the petitioner's bid, which has not been considered now, is now rejected. In the light of the High Court of Calcutta, granting interim order in WPA 18-476 of 23, which is still now continuing, and the interim orders continue. I am of the view, respondent shall open the financial bid of the petitioner, which would be subject to the outcome of the writ petition. It is needless to mention, petitioner cannot claim equity in the event of their petition being dismissed. Now, please look at the next page, page 28, final order. I was, my lord, found page 29 Bandratavu. Sorry, 30, my lord, 30. Paragraph 3. Paragraph 2, my lord, sorry, para 2. Pending consideration of the captioned petition, learned standing counsel appearing for the response, however, brought to the notice of this court, bids have been opened. Bid was, my lord, directly opened by my lords. Petitioner was found an unsuccessful bidder. Therefore, in view of the statement made by the learned counsel, because he was, my lord, I was L2 then. Counsel appearing for the response, captioned petition does not survive for consideration. At this juncture, learned senior counsel appearing for the petitioner would, however, bring to the notice of this court that since the High Court of Calcutta has granted interim order, rejection of the application by the respondent would be stigmatic and impediment in the future tender participation. If the petitioner has the benefit of an interim order, there shall be no impediment to disclose the grant of interim order granted by the High Court of Calcutta in future tenders by respondent KPCL. In view of the matter, writ petition is disposed of. My lord, all that I am saying is, at this juncture, it is premature. And my lord, this honorable court has cautioned, if you start interfering at every stage, my lord, when my lord, in that writ petition, that 2016, Justice Bopannas, rejection of the tender, my lord, on the basis of, my lord, he was not technically qualified. Then he came. This court said, sorry, this is not the stage. Similar to my learned friend, my lord, it was the premature stage. So is the case here, would be my submission before your lordship. That's all, my lord. Otherwise,
I want to say something.
No, but I think
My learned friend, my lord, now, when his technical bid was rejected, came to this court and an interim order was granted in his favor, saying open his financial bid. Isn't the same principle applicable to him then? To say it is premature, he cannot come to court.
so now, considering the scope of judicial interference, when the court has gone to the extent of saying, finally, public interest will prevail, private interest must be subservient to that. Any delay in the process is only going to affect the public interest.
Remember,
Now, all your contentions well taken could have also been a subject matter of appeal under section 16. It would be kept open to be finally decided.
till I can't.
He can, my lord.
Can't.
My
1
learned
minute.
friend has
So
raised
1
the
minute.
plea that, my lord, the secretary is, my lord, the decision-making authority on identical set of circumstances when similar occasions, my lord, occurred. This honorable court has directed the government to, my lord. I'm sure my learned
My lords, that
another secretary to look
Sorry,
doctrine
one
of
second.
necessity, my lords. Either doctrine of necessity or the ACS can then transfer the file to another ACS. That's
No,
what
no,
is
that's
correct.
a different
So-
thing. This is
No, now we are on a larger
Yes.
issue that your contentions is still something that could be raised at a subsequent stage. There is no irreparable loss or prejudice that is caused. Even if there is some prejudice, that is an aspect that could be looked into once the final decision is taken. What final decision is taken, what evaluation criteria is going to be taken note of, we don't know. The lowest bidder is not necessarily always to be evaluated and selected. Your contention will be kept open. If it is raised at a subsequent time, we say that if the technical bid still vitiates, then the entirety goes. We'll keep it open,
Wait.
only considering the broad scope of judicial interference.
my only request then, Lord, is when they take that decision, let them communicate it to me.
Definitely, my lord. They'll have to.
They won't communicate it to anyone. Let them communicate it to me before they award the tender.
My lords,
Sir, I have at least one
my
day
lords,
to come before the
just
court.
one submission, my lords. Whatever is provided in the statute is what I'm required to do. If my lords is specific, if he says no, you should write an order to me, then my lords it creates further complications.
No.
Then they let me make my submission is, my lords, the rules are very clear, my lords. Rule 26 says I have to publish an evaluated report and a tender upload it to a tender bulletin. I will make sure that it is uploaded there and he will get access to it from his e-portal. Beyond that, my lords, if an order is directed to be passed, it creates complications. That's my submission.
The petitioner.
His submission, Lord, I understand that his submission is they will still evaluate everything and then take the decision,
Yes, yes.
or both technical and financial.
Yes, yes.
Wait.
The petitioner has sought for a declaration that the technical bid of respondent number 4 was not responsive and hence not eligible under the notice inviting tender at annexure E. Petitioner has also sought for setting aside opening of the financial bid of the respondent number 4 by respondent 1 to 3 as well as all actions pursuant thereto. Petitioner has sought for direction to respondents 1 to 3 to proceed with consideration of financial bid after excluding respondent number 4 from the process. It is a case made out by learned senior counsel Sri Dhyan Chinnappa appearing for the petitioner that the fourth respondent's technical bid being defective, question of opening the financial bid did not arise. Full stop. It's further submitted that once a technical bid is found to be defective, question of progressing to the second stage does not arise. Senior Counsel Sri Udayola appearing on behalf of the fourth respondent would submit that the interference by way of judicial review in tender matters at an intermediary stage when a final decision is not taken by the tender accepting authority would be premature. Reliance is placed on the judgment of the coordinate bench in NEC Technologies India Private Limited versus Shimoga Smart City Limited 2019 SEC Online Karnataka 4343, the decision of the coordinate bench in the case of G. Shankar versus KBJNL reported in so and so. ILR 2016 Karnataka 4790. Third counsel appearing for KPCL Sri Ajay Nandalike asserts specifically that under Rule 20
24 24(3) the 24(1) ನಲ್ಲಿ ಇನಿಷಿಯಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ.
just that the evaluation by way of initial examination under Rule 24 and
if I can just
and under 24(3) result of such initial examination is still not final and a final decision may be taken under Rule 26(1) by the tender accepting authority. Full stop. It is submitted that the final decision under Rule 26 of the tender accepting authority would have the effect, would invest the tender accepting authority a substantive power to go beyond initial examination under Rule 24. Full stop. Said submission is taken note of. Though learned senior counsel appearing for the petitioner submits that such procedure as laid out by the counsel for KPCL would be contrary to the tender document. We would make it clear that the stand of counsel for KPCL could be taken to be an accepted procedure as one flowing from the rules. And needless to state, the tender procedure cannot be contrary to such rules, that is the Karnataka Transparency in Public Procurement Rules 2000. Next. Even otherwise, court is of the view that interference at this stage may not be appropriate, as there should be free play by the decision-making authority, and it's an accepted proposition that minor variations in procedure need not necessarily lead to court exercising power of interference by way of judicial review. Accordingly, court is of the view that the contentions of the petitioner regarding defects in the technical bid of respondent number 4 are matters that could be taken note of. Once under 26(2), the tender accepting authority finally takes a decision. All such contentions of the petitioner are kept open. It's clarified that the decision, the initial examination under 24(3) is also a matter that is kept open in the form of legal contention if need arises in subsequent litigation, in subsequent litigation relating to the same tender process.
And then put it up on the tender.
The respondent KPCL to ensure that the procedure of making known the acceptance of the bids and the decision of the tender accepting authority under Rule 26(2) is communicated as per settled procedure.
Amrit.
47, Vivekananda.
For respondent, my lord. In this matter, let's have challenged the demand notice issued by the BWSSB, Annexure J, page 74. When I sought for water connection to a residential apartment complex, that this demand notice has been issued, page 74 minutes. There are three components. 74 minutes. Annexure J. Here there are three components. One is 6,47,050. This I need to pay. There can be no quarrel about it. The next component is pro rata charges. Next page, it is in the 2,99,25,390. The other component is 52,16,497. That is BCC charges. The grounds of challenge of this demand notice is that it is a residential complex, and
no, now who appears?
That's Mr. B.L. Sanjeev appears.
Sanjeev appears for BWS.
Respondent 2 and 3, my lord. US date of hearing, no.
Readings are complete or first time?
No, but the interim prayer is yet to be considered. That's on the previous date of hearing. They were directed to take notice, and matter was listed for consideration of interim prayer.
But these BCC matters, my lord, have been disposed of by the coordinate bench of this court, where it had the other two components, that is the Greater Bangalore cess and the beneficiary capital contribution, have been struck down.
I'll point out, those are the cases.
So you appear?
Respondent 2 and 3, my lord.
The BWSSB.
BWSSB.
So what is your stand?
It's in identical cases.
Objection.
May I point out, out of the demanded amount, I am ready to deposit 50%, subject to result of the writ petition. My ground of attack of this demand notice is they are charging pro rata charges to the extent of 2,99 lakhs. Pro rata charges, according to them, is for supply of water and sewage connection. But
now I'm saying at this stage,
yes,
it could only be said whatever you pay would be subject to outcome, and then we'll decide.
Yes, they need to give a water connection at least for the time being.
So you pay it, that will be subject to the outcome at this stage.
I am ready to pay to the component of 6,47,50,000 and 50% of 2,99,25,000. I am ready to deposit about 1,55,60
But then
lakhs.
we'll have to find out. Let them take their stand.
The reason because in a residential project, the setting up of a STP is made mandatory.
Correct,
That
but
there is a zero outfall from the
any-
residential
correct,
project.
but any interim order
Yes, ma'am.
will have a cascading effect in all matters.
At the identical circumstances, when this honorable court passed an interim order in a writ appeal, I produced annexure P, annexure Q, page 95. Similar demand notice was challenged and matter was taken to honorable division bench. Subject to deposit, the water supply connection was directed to be.
Just read.
Merit the entire order. Yes, heard learned senior counsel so and so, so and so. The appellants are the original petitioners who have called in question the impugned and judgment and order dated so and so. The petition came to be disposed of by issuing directions on the lines of writ petition number so and so. The dispute in the main petition was with regard to liability of payment of Greater Bangalore water supply and sanitation project charges and beneficiary capital contribution charges, which was approved to be collected by the respondent number 2 Bangalore water supply.
So 3.2 you are challenging, is it?
Please minutes. And minutes the class paragraph number 5 minutes onwards, it appears that thereafter on 13/5/2024 an intimation letter was issued to developer of the layout of residential project where the appellants have been staying in their respective residential houses, asking to clear the charges mentioned in the aforementioned notices, which are the pro rata charges and the other charges, requiring the appellants to pay the same within 7 days. It was stated that unless the charges are paid as demanded, water connection will be disconnected without any further notice. It could be seen that rupees 92,40,000 was demanded on 17/5/2022 for domestic HR. Water supply and sanitation connection. Water supply is essential utility, more particularly for those who stay in the residential houses. Supply of water is inevitable to maintain the day-to-day activities and the affairs in the house. In the circumstances, interim relief on that count deserves to be granted. Respondent board is required to be restrained to take any coercive steps. It was stated that the water connection is already disconnected by the board and the appellants have been without water connection. In the aforesaid view, it is provided by way of interim relief that the appellant shall pay 50% of the amount of rupees 92,40,542, and upon payment of such amount of 50%, the water supply shall be forthwith reconnected by the board. Then so and so, so and so. But in this case, water connection is not yet given. It is at the initial stage. When I made an application for water connection, this demand is made. But I am prepared to pay 1 crore 60 lakhs.
No, the point is that the validity of this demand. If we make as 50%, then in every case, same order will apply in all matters. So let them take a call.
But the reason because the entire project is completed and the prospective buyers have booked the flats and the occupancy certificate is yet to be given, and BBMP is insisting for furnishing the water connection communication. If I produce the water connection intimation, they would issue the occupancy certificate. Your lordship may kindly put me on condition. If I fail,
this will be used in other matters also. So we don't know what the legality is. Let them take a call. If they say that this interim order of the division bench.
I would file an affidavit before this honorable court that I'm ready to abide by the decision that would be rendered at the ultimate stage. And I am a builder. I can't escape from the clutches of either BBMP or BWSSP or from this honorable.
No, that is there. But we look into the validity of the claim. We'll hear them.
No, the main ground which I have urged in is they are charging this amount for water supply and sewage connection. Now, our project is a zero outfall. As per the condition imposed by Pollution Control Board and the BWSSB, that there would be no outfall from our project. Neither the rainwater nor the sewage. I have to treat every drop of sewage water in the STP only. I have spent more than 1 crore for setting up of the STP. Kindly see the photographs which I have produced.
I'll have it tomorrow. You ask Sanjeev.
Please.
Relist tomorrow.
Public.
48.
Annexure A, the rowdy list is under challenge. Rowdy sheet, I have been rowdy sheet.
My lord, in this case,
I will make my submissions.
I'll file my objections.
No, my lord,
objections are ready.
Right.
Objections are ready.
I will make my submissions.
Right.
This court has laid down guidelines for the purpose of opening a rowdy sheet. This is in violation. May I pass it on? System.
Page number 2, my lord. Guidelines for rowdy house history sheeting. Before entering the name of an individual to the register of rowdies, the jurisdiction police shall collect and collect the material information concerning him and frame the proposal for registration on that basis. A brief proposal notice shall be sent to the individual concerned in a sealed cover with an option to submit his representation within 2 weeks as to why his name should not be registered as a rowdy. However, there is no need to afford a personal hearing. In exceptional cases, notice may be dispersed with for reasons to be recorded in the register of rowdies. May I kindly take your lordship to the impugned order, my lord. Annexure A.
Annexure.
Page 13. Type copy is at page 14, my lord. Peruse the report of the Chennai Police Inspector, Nirvandelli Police Station, Hoskote, Subdivision, Bangalore District. It is evident Santosh Kumar, son of Krishnappa, is 38 years, Kamma caste, real estate, Siddhanapura village, Nirvandelli Obli, Hoskote Taluk, Bangalore District, has often indulged in acts of violence culminating in breach of peace and disturbance of public order. It is felt that it is essential to have his movements watched continuously. Hence, I pass. No notice. And I should have been informed about I being charge sheeted. That is also one of the contemplation in the guidelines issued by the Supreme Court. And kindly see Annexure C, Malad.
So this order is passed on.
This is subsequent to the judgment of the Supreme Court, 15/5/2024.
24.
Let us see you. When do you want it?
Next week, any date, my lord. I'll file my objections.
Wednesday.
Ready? I'll file it
Wednesday.
today. Yes.
But you have to take a stand on the judgment
Yes,
relied
ma'am.
on,
I'll
irrespective of the merits.
And the circular has been issued
Irrespective of the
subsequent to
merits.
the.
They're saying this is a procedural, without entering into the merits, it's a procedural lapse.
Annexure
Only-
G, the
only
higher
on
up,
this
higher
ground
up
it
the
has to
police.
go.
Yes. DIG has issued circular to all the police officers to follow the procedure as contemplated in the guidelines. Annexure G at page 37. Lakh. That is also not followed.
The counsel appearing for the petitioner submits that before the impugned order at annexure A was passed, the procedure as laid down in WP, the guidelines
Write down by this court.
as noticed in the case of B.S. Prakash versus State of Karnataka in WP 4504 of 2021 has not been adhered to. Full stop. It is submitted that there was no notice to the petitioner prior to order being passed at annexure A. Full stop. The respondent state to specifically take a stand with respect to non-adherence of the procedure prescribed referred to above. Relist the matter in the preliminary hearing list on Wednesday date.
Please. Till then, let them not. Every day I've been called in the police station.
Now let us see.
Not my respective submission. I've been made to wait in the police station till 10 o'clock in the night. That is I moved the vacation court also, my lord. Let them not precipitate the issue till the matter is heard and a decision is taken by the lordship. There's a gross violation of the orders of the Supreme Court as well as their circular also.
Orally, you instruct them not to
Yes,
take
ma'am.
any action
Not
till
to
the
call
next.
him into the police station.
Now, there are two parts. One is on merits. Other is the procedural. They are saying, irrespective of, you may have a good case on merits. You may only have to redo it.
Yes.
But after following this.
Yes. Okay, date will be fixed, madam.
Wednesday.
Please.
Huh? No, disposed. ಯಾವುದು dictate ಮಾಡಿರೋದು. Huh. ಬೇರೆ ಬೇರೆ ಅಷ್ಟೇ ಡೇಟ್ಸ್ ಕೂಡ ಅಷ್ಟೇ.
49, Ramesh Kulkarni. Respondent number 7 in this.
B group matters, you can request for dates before the court officer, dates will be given.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್ ಎಲ್ಲ. ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಹ್ಞೂ ಸರ್, ಅದು ನೆಟ್ವರ್ಕ್ ಸರ್. ನೋಡಿ ಮೇಡಮ್,
serial number 50.
ಬಿ ಗ್ರೂಪ್ ಡೇಟ್ ಅಂತ ಹೇಳ್ಬಿಡಿ.
ಚೆನ್ನಾಗಿದೆ.
ಬಿ ಗ್ರೂಪ್ 52 ಸೀರಿಯಲ್ ನಂಬರ್.
ಇಲ್ಲ ಇಲ್ಲ,
ಈ ವೀಕಲ್ ಹಾಕಿ ಸರ್.
ಸರ್ 50 ಸೀರಿಯಲ್ ನಂಬರ್.
ಆಕ್ಚುಲಿ ಬಿ ಗ್ರೂಪಿಗೆ ಬರೋ ಹಾಗಿಲ್ಲ ಸರ್ ಅದು. 52 ನನ್ಗೆ ಈ ವಾರ
5011 ಓಕೆ.
54 ಸರ್, ಮಂಡೇ ಪೆರೋಲ್ ಮ್ಯಾಟರ್ ಸರ್.
ಪೆರೋಲು ಅದು ಆಕ್ಚುಲಿ ಬಿ ಗ್ರೂಪಿಗೆ ಬರೋದಲ್ಲ ಅಲ್ಲ ಸರ್, ಅದು ಸುಮ್ಮನೆ ಬಿ ಗ್ರೂಪಿಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಹೌದು 13 ಅಲ್ಲಿ ಬಿಫೋರ್ ಕೊಡ್ತಾರ ಅನ್ಕೊಂಡ್ ಪೆರೋಲ್ ಅಂತ ಹೇಳ್ತಿದೀವಿ ಸರ್. ಪಾಪ ಆಲ್ರೆಡಿ ಅವ್ರ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿ ಎಲ್ಲ ಆಗಿದೆ. ಬಿಫೋರ್ ನಾಗಪ್ರಸನ್ನ ಅವ್ರ ಮುಂದೆನೆ ಆಗೋಗ್ಬಿಟ್ಟು ಅವ್ರು
ಸರ್ 9th ಸರ್ 54.
ಅದು ಬಿ ಗ್ರೂಪಿಗೆ ಬರೋದಲ್ವೇ ಅಲ್ಲ ಸರ್ ಅದು.